photographs, and other documents that comprise the case record. At the conclusion of the staff presentation, the appellant will present his or her case to the board. After the appellant's presentation, the board would hear from those wishing to speak in support of the appeal. Thereafter, the board would hear from those who wish to speak in opposition to a case. After the opposition presents its testimony, the appellant will have the opportunity to present a brief rebuttal. Under the Board of Zoning Appeals rules, the appellant has 10 minutes for a presentation in non-contested cases. In contested cases, however, the BZA rules allow 15 minutes for each side to present their testimony. Given that there are a number of people here on a number of cases, it is imperative that everyone grasp. That's 15 shared minutes. Not everybody in the room gets a 15-minute bite at the apple. So, for those who are here in groups, we would encourage you to organize your time accordingly so that you get the most bang for your buck with the 15 minutes. In the event that the appellant wishes to reserve some portion of the allotted 15 minutes for rebuttal, please note at the beginning of the presentation. At the conclusion of each of these hearings, the board will deliberate and then vote on each case. The board is vested with the power to act on these cases under the provisions of the Metro Zoning Code, namely Section 17.40.180. All the section numbers that we refer to today come from the Metropolitan Code of Laws and specifically the Zoning Code in Title 17. The Zoning Code was adopted by the Metro Council and put into effect on January the 1st of 1998. I'll make the entire Zoning Code part of the record for each of today's cases. The Metropolitan Code requires a record of these proceedings. Because BZA meetings are recorded and broadcast on public access television and later uploaded to YouTube as well, it is imperative that anyone wishing to address the board come forward, activate one of the microphones, identify yourself by name and address, and then make the desired presentation to the board. The Metro Code requires 4 of our 7 board members in order to establish quorum. The code also requires at least 4 affirmative votes in order to grant an appeal. In the event that 5 or more of our board members are present but an appeal fails to receive 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days will be deemed denied by operation of law. Pursuant to board rules, an aggrieved party may appeal board decisions to the Chancery Court within 60 days of today's hearing. Additionally, an aggrieved party may file a motion for rehearing within 60 days of the original hearing date, pursuant to the terms of the Board of Zoning Appeals rules and regs. After that time elapses, the board's decision becomes final and no further action can be taken. For the appellants, if your appeal is granted, you are actually required to pick up the permit for which you've applied. A permit must be obtained within 2 years of board approval in order to remain valid. After such time, you'd be left to go back to square one with your appeal again. It should be noted that if any false or misleading testimony is presented to the board, any board approval could be revoked at a later date by means of a show cause hearing before the BZA. Mr. Chairman, I would submit that all the cases have been filed in the proper order, all appellants have been notified by certified mail, and all legal notice requirements have been fulfilled. A couple of preliminary announcements for our board and for the benefit of the members of the public who are in attendance. We have 1 withdrawal and 3 cases that have been deferred. The 1 case that was withdrawn is case number 207 involving the property at 2813A West Kirkwood Avenue. And that case has been withdrawn. We have 3 cases that have been deferred to later dates. First, the top case on the agenda, 2016-127. That case has been deferred to September the 7th, and that involves the property at 5056 Pine Valley Road. The second case that has been deferred is case number 2017-178. That involves the property at 105 45th Avenue North. That too has been deferred to a later date. And finally, case number 2017-199 involving the property at 3535A Hermitage Industrial Drive. That case has been deferred to October the 5th, 2017. Mr. Chairman, here at the outset of this meeting, after our announcements, we'd like to use the opportunity to recognize the elected officials who are in the audience, and I know there are several here today. I know I saw Council Member Jacobia Dowell, spoke with her briefly. Council Member Dowell in the audience? Not at this moment. We'll check for her in just a moment. Oh, good. I couldn't see you behind the large column. Councilmember Dowell, did you wish to address the board?
Yes.
Very well. There you are.
Oh, Councilman Dell, please press the button.
I
Yes.
always forget that.
I'm not David Briley, so I can't turn them on automatically.
Well, you're a David. Close enough. Let's see. So thank you for all being here and also serving on this board. I am Council Lady Jacobia Dow, and I'm here to speak on behalf of appeal case number 2017-205, and I am asking that you deny this request. I am not certain, but I'm hoping that you received some of the letters that neighbors sent to you regarding 312 Clark Hill Crossings Drive, and that's why I came down today. I want to share just two quick ones with you in my time allotted, but one is from Alice L. Boeing, who is president of the Homeowners Association, and she's reached out to all the neighbors in the Ashford Crossings community and had conversations with them. And she sent a letter, and she said, I'm corresponding in lieu of a personal appearance, and as president of the Ashford Crossing Homeowners Association, I request that this letter be part of the record. She said, I and other neighbors received notification of Ms. Karen Fairbairn's appeal of the zoning administrator's denial of a short-term rental permit, and I've personally attended sessions held by the Metro Council to discuss the concerns on both sides of the issue prior to knowledge of this specific case. Both sides' arguments are compelling. However, I and other homeowners in the Ashford Crossings community purchased our homes with the understanding that our conduct as residents of this neighborhood will be directed by the Declaration of Restricted Covenants for Ashford Crossings, which is the controlling governing document, and new resident buyers purchasing homes in this neighborhood obtain a copy of this from the management company. And it talks about section 3.21, the use of the premises, and basically it states that each lot shown on the plat shall be used, and it emphasizes added, for private single-family residential purposes and not otherwise. Therefore, Ms. Fairbairn's requested use of the premise is contrary and in violation of our restrictive covenants. And I know from a personal perspective, she goes on to say that she purchased her home with the understanding and the document assurance that the community is zoned residential and that is to remain so. Therefore, now I'll leave that one at that. I want to read another one. It's short as well. This owner is sick and staying with family members up north, so his daughter is looking after the place. There are 6 to 9 different people that are staying there. I've called 911 once at 1:30 a.m. They were fighting in the street, threatening to shoot each other. The second time I called the cops, their group was in 2 different vehicles, and they were smoking pot and shooting up. Both times the cops took over 45 minutes to get here, and by that time they were gone. I'm not sure what to do, but we have small kids, and I'm fed up with their crap. This letter I read to you because I think it epitomizes all the notifications I've received over the last few years on this property. I had no idea what was going on there. I thought maybe it's just a domestic situation that we see. I had no idea that the owner was sick, that it was being used. I don't think most of the neighbors have shared with me that they don't want to come here and speak out because there's drug activity involved, and they live in this neighborhood and have children, and they fear the repercussions of it. But the overall opinion of the people in the community is that this is not operating like just a regular short-term rental that people have, that we have in our community, and people do support some of them. But it seemed like to me it's like a boarding house of some sort where people are just coming and going and doing everything, and they're not being respectful to the people in the community around it. A lot of the people live around them, have families, they have children, and this activity is not good for a neighborhood. And so I ask that you take this in consideration as you render your decision. One important thing I want to mention before I close and leave is that this neighborhood is right next door to Cane Ridge Elementary School. It's the largest elementary school in the city of Nashville and Davidson County right now. And it abuts 2 other large communities, which are some of the best communities we have in our neighborhood, very active neighbors, very family-oriented, kids run through the neighborhood. And we personally do not need this kind of activity going on in the community. If they were operating just a short-term rental where people come in and stay in a week and going and so forth, and respectful of what's going on around them, I don't think, people would have these strong opinions about it. Even though it's against their CCRs, which clearly state that you cannot have one. The second piece is that, they suspect drug activity, and I have asked, and I hope you got this, the police to send a report. He put on here, he said officers received about notification about threats. They didn't see any weapons, and that the males left on foot, and they were dispatched at 2:24 a.m. and they ended their call at 4:06 a.m. So I've asked, and I know it take a while for you to get police information, but to send that, find it and send it to you. But please keep this in mind, and I ask that you deny the request.
And can you make the letters that you read to us part of the record and give them to John Michael?
Yes, I will give you these copies, okay?
Okay, before you leave, any questions for Council Lady Dowell about this particular use? How many calls do you think you've gotten about this? And it seems like this is more than just one occasion?
It's absolutely more than one occasion. And what I've heard, what I've understood, just from, and I'm going through my emails, and I thought you would have these. If you don't, I'll forward you more. I think they started when this neighbor became sick, and I guess it was empty for a while from what I understand, and then the daughter or someone started kind of living there and taking over the property. And that's when I started getting emails about it, and the emails was about parking, which we see that quite often. And it's an issue, but if they park on the street, they can park on the street. So when you see a bunch of cars parked there, so that was one of the first notifications I had. And then I had calls about like noise, the fighting and all that. But yes, it's been more than one. I would say, I think I've gotten probably like 4 or 5. Alice Alice is also an attorney, but she's the HOA president. I would have to get with her to see how many people have complained to the HOA, but most of the time they call me and say, this is what's going on, or I suspect some kind of activity or something's happening here. I don't know what. But, I'm a neighbor. I don't want my name associated with it. I fear that retaliation. And so with that, they are apprehensive about coming in and giving their name and so forth. And but it's been more than one.
Okay.
It's been several.
Thank you. Any other questions? Thank you.
Mr. Chairman, I know we also saw Councilmember Berkeley Allen in the audience a moment ago. You want to wait? Very well. She'll wait until her case is called up. Councilmember Jeff Syracuse also in attendance today. Councilman chooses to wait till his case of interest is called. And then Councilmember Steve Glover also present today. Councilman, do you wish to address the board?
Yes, please.
Very well.
Thank you, Chair and members of the board. I'm here to speak about 2017-183. As I think each one of you guys are aware, and thank you also for the service that you do for the city. We appreciate it. I think it's really easy for us to understand what you guys give up in order to do this, and so thank you. In addressing this particular case, as you know, the council is wrestling pretty hard right now with how do we handle STRPs, how do we manage those things. We have very clear rules in place on what you have to do with regards to getting a permit and the reporting you have to do, et cetera, et cetera. It's my understanding, and if you don't mind, Mr. Chair, I'm going to ask the legal counsel to give the entire board with me here an overview of what the codes inspector has seen. I'll wait until he is.
Are you talking about specific things that they have found?
Yeah,
with this?
specifically. So if I could.
That might be more of a
yeah,
John Michael.
It is a John Michael question. If I could, Mr. Michael, can you tell me what the codes inspector has done, and can you tell me the activity that's occurred up until even through yesterday, so the board can hear the activities that have taken place from our side,
Sure.
The government side?
Sure, and just for the board's edification, again, this is case 183. The property is located at 5229 Earhart. The Property Standards Inspector from the Codes Department actually posted a stop work order at this location on June the 19th, and that was based upon the operation without the legally required short-term rental permit. As recently as yesterday, August 16th at 3 p.m., when I checked the listing at vrbo.com, the listing was there plain as day, still up as it always has been. There have been documented reviews, which of course we always take to be evidence of actual operation. Again, no permit having been issued, there's no operation or advertising allowed in that scenario. So in this instance, not only has there been enforcement action taken, there has been apparently in the 2 months that have passed since that original stop work order, no even fundamental rudimentary compliance.
And with that, Mr. Chair, I heard you ask Council Lady Dowell if there was written evidence we could provide. I did not have that, so that's why I asked your indulgence in order to hear Mr. Michael and what he had to say. That being said, we clearly have rules that we've made, and we're struggling right now with what do we do with this particular issue as we go forward in this city. How do we manage those things, and how do we be fair, all right? When we clearly have a violation of the code, and here in my opinion we certainly do, then I come to you and I ask you as strongly as I can to deny the request. All right, we have the rules for a particular reason, and so therefore that's my major, I guess, comment to you today in order that this not be allowed to continue, because I think we need to send a message out there. If you want to do it, that's fine. The council has said you can, but you've got to do it legally. So with that, Mr. Chair, I appreciate your indulgence.
Any questions for Councilman Glover?
So you've gotten complaints about this property?
Yeah, I've had some neighborhood associations reach out to me, yes.
And then one of the things in my notes that came from the reviews, because they always give those in the packet, it says it, that it sleeps 18, which is another violation of the rules too. So have you had evidence from the complaints that it's?
I worked everything through Mr. Brandon Burnett in the council office. As you well know, he kind of is our liaison now with planning. And it appears to me there's a number of violations. Can I specifically say they're doing this or they're doing? No. I think the strongest point, and I guess the greatest argument that I make right now, is that they're operating without a permit. They know what you're supposed to do. They've been given notice, and had they have acted properly, we may be having a different conversation. But I don't think it did, and so therefore that's why I take the stance I've taken.
Okay.
Thank you, Chair.
Councilman Glover, thank you. John Michael.
Mr. Chairman, other council members present. I believe Councilmember Colby Sledge from District 17 is present and wishes to address the board.
Good afternoon, Board. Thanks for your service, as always, and I know you always have a lot going on in District 17. I wanted to run through very quickly on the agenda the items that are in District 17. The first one that you'll end up taking up is 2017-163. There's a two-part request. As you see on your agenda, I believe what you will hear from the applicant or the appellant is that they will be dropping the special exception request. This is Beach Avenue. They will be moving forward with the sidewalk variance request to build to the current sidewalk, well, the previous sidewalk standard and not the new sidewalk standard. I believe neighbors are here as well. You'll hear from both of them. The real issue that I heard from residents was a special exception. I personally probably would like to see the new sidewalk standard be in place, but I leave that to the board and to the testimony that you'll hear.
So you're really not taking a position on this case?
On the sidewalk variance, I would prefer that they meet the new standard. But the real issue that we were facing between neighbors and the applicant was the special exception issue. But I do want to make clear, the position I heard from neighbors was they were against the.
Okay.
And is it your understanding it's still a 9-unit?
It would not be if they don't get the special exception. I have not been given a unit number that it would be, but my understanding is that they would not be able to build to that unit count, unless I'm mistaken. The second one that is on yours is one that's come before you before. This is 2017-182, the King's Interiors appeal. I have spoken a couple of times with the appellant. We received the basically documentation that we were asking for from zoning that shows that another issue I think has been resolved. I feel that they probably will fall within the request that, regarding a front staircase that they need. They need a front setback request. I feel comfortable with them receiving that request. The third one I believe is going to be moved off, which was West Kirkwood STR. I believe that's been withdrawn. And then the final one is on consent, the 308 Chestnut Street one. I just wanted to note, very much appreciated planning's work on this. They provided me kind of their rationale, the agreement they came to with the property owner, and I think it's a great model for how we'll deal with these moving forward. So, thank you, Board.
Any questions for Councilman Sledge? Thank you for being here.
Thank you.
Mr. Chairman, we'll of course remind the other 34 or 35 council members are welcome to join us anytime. We always make time for them at the outset of the meeting if they'd like to join. Appreciate the input from all of you as it really helps the board in their deliberation over these cases. For members of the audience, our board utilizes a consent agenda. One board member reviews each of the cases from today's docket and identifies those cases where appellants have generally met the criteria for the requested action, and if the reviewing board member determines that testimony from the case would not alter the material facts, then that case is recommended to the board for approval on the consent agenda. We will enter into the record those cases that have been so recommended, and if anyone is here in opposition to one of the cases recommended for consent agenda, just raise your hand, make sure I see you. We'll remove it from consent agenda and have the case heard in its regular order without any problem. Mr. Chairman, there are, I believe, 5 cases recommended for consent agenda today. The first is case number 2017-194 for property located at 4421 Soper Avenue. The request is for a street setback variance. Is there anyone here in opposition to case number 194? Seeing none, we'll identify the second case from the proposed consent agenda, case 2017-200 for property located at 101 Lanewood Court, a request for a rear setback variance. Is there anyone here in opposition to case number 200? Seeing none, case number 2017-201 is the next one at 411 West Trinity Lane, a request for a variance in order to install a commercial car wash. Is there anyone here in opposition to case number 201? Seeing none, the next case recommended for consent agenda is number 2017-212 involving the aforementioned property at 308 Chestnut Street. The request is for a sidewalk variance to keep the existing sidewalk rather than build to the new standard. It should be noted that this is recommended for consent agenda specifically with the Planning Department's recommended conditions. So a vote for the consent on this particular case, again, necessarily includes those 2 conditions.
And what are they for the record?
The first had to do with the planting of street trees at 30-foot intervals. The second had to do with restriction of access along Chestnut Street, as this is a corner lot.
Okay, good.
Finally, is there anyone here in opposition to case number 212? Seeing none, the final case identified for the proposed consent agenda is case number 2017-213 involving the property at 1109 Summersby Court in Bellevue. Is there anyone here in opposition to case number 213? Seeing none, we have for the board a proposed consent agenda of cases 194, 200, 201, 212 with the planning conditions, and 213. Mr. Chairman, I would solicit a vote.
Okay, those cases have been made and moved to the consent agenda. Is there a second?
Second.
Motion's been made and properly seconded. Any more discussion about the consent agenda? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes unanimously. John
For
Mike.
those cases that were identified for the consent agenda, if that's your case, you're all done, and you're welcome to leave if you wish. You're welcome to stay, of course. But those cases, 194, 200, 201, 212, and 213 have been approved. If you'll give us until Monday, we'll have the orders drafted and our staff ready to issue the permits as requested. Mr. Chairman, there has been a discussion or a question raised as to whether the board would like to move the one item A case to the top of the agenda. That's specifically case 2017-181. We'd solicit a vote if
Yes.
that is the board's intent.
Yes. Okay, is there a second? Okay, a motion's been made and properly seconded to move this case to the top of the agenda. All those in favor signify by saying aye. 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 Oh, discussion. Does that have anything to do with this?
Yeah, I just want to make sure it's
Okay, I think we'll have a quorum. Okay.
With that, we'll move case 181 to the top of the agenda. The rest of the docket will remain intact.
Okay, very good.
And absent any announcements from the board, we'll continue with our first case, case 2017-181, an item A case involving the property at 206 Fairfax Avenue. The appellant is Joe Petraska, challenging the zoning administrator's interpretation of the applicable law with regard to setback for this particular property and its proposed development. Councilmember Berkeley Allen is also here and will have the opportunity to address the board whenever she likes, whether at the beginning, middle, or end. Thank you for being here, Councilmember. After that, the opponents will have the opponents of the item A, the proponents of the project, will have the chance to address the board as well. Councilor, you'll have obviously the full 15 minutes. If you wish to reserve some of that time for rebuttal, just feel free to note it and we'll mark it accordingly.
And John Michael, this is an item A case. I would like to hear from the zoning administrator about his opinion on this. So Mr. Herbert, can we hear from you?
Yes, absolutely. John, do you want to go ahead and give your pictures and staff presentation before I do?
Sure. For members of the board, this is the zoning map that shows the property as it comes right to the terminus of Fairfax Avenue, and just below West End Avenue, you see the cloverleaf from the 440 exit ramp there for the West End exit. The aerial gives you an even better feel of the presently unoccupied property, previously housed a daycare at that location. I believe that's the main part that we have. The aerial seemed to be the best telling of the story in terms of the condition of the lot, its proximity to 440, its proximity to the condo tower beside it, and the single-family residential street Fairfax that runs along there beside. Mr. Herbert.
Members of the board, I appreciate the opportunity to address you on this, and appreciate that you've moved it to the top of the agenda. I have to leave today promptly at 2 o'clock for a meeting up at the mayor's office, so thank you for allowing me the opportunity to speak before I have to go. I'll make this relatively short and kind of to the point, and leave it to the attorneys for both sides to make their arguments. For me, the issue here is which side of this property should be designated as the front. And the reason that that's important is because if you know which side is the front, then you know where the front setback is to be measured from. You then know which is the rear, and you know the sides. And so for the purposes of orienting a building on the lot, it's really, really important that you know which side is the front, which is the side, which is the rear. In this case, what I was charged with initially was I need to determine what's the front for determining what is the front setback or the street setback. Those two terms are used the same. Street setback under the zoning code is defined as follows, and this is really important. Street setback means a setback extending along the full length of the lot line abutting a street. Now, the two words that are really, really important there are the words abutting and the words street. Both of those are important, so I'm drawing your attention to that. Under the zoning code, the word abutting is defined really in relevant part to mean touching or sharing a common point or line. The term street is defined as a publicly maintained right-of-way other than an alley that affords a means of vehicular access to abutting property. Now, of note, alleys are not streets under the zoning code. So, in this case, and if we look on the screen, we have only one street that abuts or touches the subject property, and that's Fairfax. It doesn't touch or abut any other public street. Now, again, there's an alley that runs along it, but under the zoning code, an alley is not a street. So, for the purpose of determining what is the front setback, it is that property line that abuts a public street. So, we've got Fairfax touching this property, abutting it, but only for about 2 feet. So, the zoning code says that to be a street, it has to provide vehicular access to abutting property. Fairfax provides access to the property for a distance of 2 feet. Now, I think it's important to note that for zoning purposes, historically, this property has been accessed through the alley. But for the purpose, my simple purpose here today is I have to determine what is the front setback. And for that, I have to follow the definitions of the terms that were put into the zoning code. So I have to find the only public street that is touching or abutting the property, and that's Fairfax. I also looked at the history here because I thought it was important to determine this lot currently is a vacant lot. So I wanted to know, have there been other buildings on this lot? And if so, which way did they orient? And there was a prior building on this lot, and I submitted it in my packet. And that building had a Fairfax address. The front was oriented to Fairfax. I went to the assessor's website and had a picture. I included it in my memorandum, and showed the property fronting on Fairfax. It was addressed to Fairfax. And in fact, the building permit that was issued on December 12th of 1973 for that building, which I included in my packet, specifically designated Fairfax to be the front of this property. So the building that was previously there was oriented to Fairfax and specifically designated Fairfax as being the front of the property. So that was what I based my opinion upon. It was upon the definitions contained within the zoning code and the history of previous buildings located on that lot, all of which touch Fairfax, the only public street. Again, the alley is not a public street, specifically excluded from that definition under the zoning code. I received a memorandum this morning from Mr. Petraska, stated it's a supplemental statements of the appellants.
And we all have copies of that, too.
Yeah, so I was just going to very quickly address that, and that is part of my job is not only to make these types of determinations, but there's a section in the zoning code that, even though it references a corner lot, it gives the zoning administrator some authority to determine which is the front. That's not applicable here, but generally speaking, we always try to use the short lot line as being the front of the property. And if even if you look at all the other properties going up and down Fairfax, without exception, you'll see the shorter lot line is always designated as the front. That's just a rule of thumb that we have. In this case, the property at Fairfax, I think what's trying to be argued there is that it is actually oriented toward West End. And I disagree with that because the subject property on Fairfax does not abut, it does not touch West End. If you look at the property that's called into question, I think it was 3209 West End is the one that's being compared to. 3209 West End is a property that literally is right up against the sidewalk along West End. I'm going to pass down just from Parcel Viewer a printout of both of these properties. Behind each one of those is the aerial photography, and I think you'll be able to see what I mean. The difference being that 3209 West End, it physically is right on top of West End, and whereas the Fairfax property is quite a distance and does not, in my opinion, touch West End. That case was a signed case. It was from 2002. There's a statement that this board is bound by its prior decisions. I think this board knows that that is not the case. Under land use law, there's no precedences ever. And why? Because every piece of property is different. This is pretty clear under Tennessee law. So you're not bound by any prior decision. I would say specifically you're not bound by the decision 2006 because it was a signed case. It involved a different piece of property in a different location, and you're not bound by that, in my opinion. I think that's it. Any questions from me?
Yeah, just there's a picture in our packet that's called Exhibit B, and it has this triangular shape. I think it's this property. Who owns that property?
That's TDEC property.
Okay, so
Or TDOT.
So this is the only property we're talking about, is that rectangle?
That's correct.
Okay. That's what I needed to know. Thank you.
And why does TDOT own this property? It has something to do with 440 most likely?
Yeah, my research indicated that it was condemned or taken back when the 440 was being cut through as right-of-way, and it has remained TDOT property ever since.
Just really as a buffer?
Yeah.
Okay.
There are no limitations or definitions on the length of a street, minimum or whatever?
No, sir.
Thank you.
Any other questions for Mr. Herbert before we start, knowing that Mr. Herbert is going to have to leave at 2 o'clock to go to the mayor's office? Okay, John Michael, let's proceed.
Very well. The appellant is Mr. Prochaska. Mr. Prochaska, please make the desired presentation on your item A case. Again, as a reminder, there'll be 15 minutes. If you have anyone else here that you want to speak in that time, know to include their time as part of the 15.
I would like to reserve 3 minutes for rebuttal, and at the conclusion of my time, I will have other members of the Hillsborough West End Neighborhood Association, as time allows, to come up and talk about some of the impacts of this proposed development. Mr. Chair and members of the board, thank you for hearing me today. I'm Joe Prochaska. I'm here on behalf of the Hillsborough West End Neighborhood Association and myself with regard to the property designated as 206 Fairfax. You heard what Mr. Herbert said, and I agree with most of what he said, except for 2 things, really. One is whether or not this property touches the right-of-way of West End. West End is State Highway 1, U.S. Highway 70. That right-of-way between this property, there is nothing between this property and the black asphalt of West End State Highway 1 other than property that is part of the state right-of-way. It abuts the state right-of-way for West End. It touches it. Now, it's a little bit further distance from some of the other properties from West End, as Mr. Herbert noted, but there's nothing in the code that says how far property has to be before something is considered no longer to touch or abut the right-of-way. As a matter of
So he had said it abutted, the word was the street, and so what's the difference between the street and the right-of-way?
Well, there's a couple of differences. One, street is a specially defined term in the code. So you can't know what a street is for these purposes without knowing what a right-of-way is. And so this is a publicly maintained right-of-way. It's owned by the state. It's part of the right-of-way for State Highway 1, U.S. Highway 70, West End Avenue.
So,
go ahead.
Can I ask you, I'm sorry to interrupt you.
No.
But I do want you, because you've made this is part of your argument, that it's part of Highway 1, and what part of it makes you convinced or can convince us that it's part of Highway 1 and not Interstate I-440? And would that make a difference? Because it only is owned by the state because of Interstate I-440.
I'm not sure that's true. If you look at what's on the screen right now that's presented, you see that the exit ramp for 440 stops at a red light right there. And after that, it turns back. That's West End right there. So you see where you can see where the sound wall runs right along there. So that's where I-440 has ended there. That's all West End Avenue right there. That's State Highway 1. It's not U.S. Highway 70. It's owned by the state, just like the rest of the right-of-way along State Highway 1 West End is owned by the state under the control of the state or Metro. It is a publicly maintained right-of-way. And this property abuts or touches it. It's not a park. It's not a designated recreational area like Elmington Park is in front of West End School. It's not. This is owned by the state as part of the right-of-way, and there's not a separate and it's the right-of-way for State Highway 1, U.S. Highway 70, West End Avenue. So It is also, as you can see from the map, part of the, what I'll call the West End corridor, the ORI zoning corridor. So it is just like all of the other 17 or 18 parcels in that zoning corridor that abut the West End right-of-way. All right? Now,
Pardon me.
Yes.
What about the vehicular access part of the definition? Is it clear that there is vehicular access available from West End to this property?
Absolutely. Absolutely. There is. And I want to, because we're
Yeah,
looking at...
I'd like to hear what that
Well, yeah,
vehicle
how so?
access is.
Okay, yeah, because that's important. Because remember, it says vehicular access. And I want to compare this with 3209, which we just talked about, or 3201, or 3205, or 3207 West End, none of which have a driveway or a cut-through to West End, just like this property doesn't have a driveway or a cut-through to West End. But there is vehicular access. The access happens in this way. One, you can do like my son did for 8 years when he was going to Metro schools, and when he took the bus, he got off on West End in front of, or got on the bus just right outside where this property lets out on West End Avenue, and got on the bus. That's
But he did it by foot. We're talking about...
Yes, just like if I go to 32, if I go to Tin Angel.
But isn't by that definition, every piece of property in Nashville has vehicle access?
No.
You could walk somewhere?
No, because it's vehicular access from abutting property. From abutting property. If it abuts the right-of-way, he could walk, my house does not abut West End, and you can walk from my house to West End. That doesn't give West End State Highway 1 vehicular access to my property.
So what is your definition of vehicle? I mean, as long as you could walk to it, it's considered...
No, it's not as if you can walk to it. And it is whether you can obtain access to this property from a vehicle, from an abutting public right-of-way.
But isn't the TDOT land not supposed to be, I know there's a sidewalk here, but that's private property, right?
No, it's part of the public right-of-way.
The
It's
TDOT.
public, it's public property. Yeah, there's a
So by your
publicly
definition,
maintained
as long
sidewalk.
as you can walk to it from
No,
West End?
no, it's not whether you can walk to it. If you took an Uber or a Lyft to this property and dropped you off, you would drop off here. You could drop off right there on West End. If you took an Uber or a Lyft to Team Nashville, just down the street, it would drop you off on West End State Highway 1, and you wouldn't have to, in either situation, you wouldn't be crossing any other property other than the state right-of-way that abuts this property. And that's the key thing here. This is part of the West End corridor. It's part of and it was zoned that way to be part of the West End corridor. It is not if you go across the alley, that's not abutting the state
But
right-of-way.
Mr. Herbert, before he leaves, he talked about abutting means touching. This doesn't touch West End,
It touches the state right-of-way.
but that's not West End.
Yes, it is.
This is the state right-of-way. What's the address of the state right-of-way?
Pardon?
The state right-of-way is a lot. It's not West End Avenue.
No, it touches the
So
property
when the
that
code
this,
says it has to touch the street, that's not a street. The right-of-way is not a street.
it is because it touches the right-of-way, it touches,
Well, can we pause? Mr. Herbert, before you leave, I want you to read what you said to us about abutting and touching and the street and what that means as far as your letter or interpretation.
Okay, so street setback means a setback extending along the full length of a lot line abutting a street. Street means a publicly maintained right-of-way other than an alley that affords a means of vehicular access to abutting property. Abutting means touching or sharing a common point or line.
So under that definition, would this TDOT right-of-way fit into that? Mr. Herbert, under that definition, would the TDOT right-of-way configure into touching this as a street?
In my opinion, no,
Why not?
because the street, for me, the publicly maintained right-of-way is the pavement, the sidewalk. It's the street. It's not the grass.
Okay, thank you. Back to you.
And I guess so, I'd pointed to this Exhibit B because this, what we're talking now is the public right-of-way was confusing to me. I thought that that involved the property at question, and I now know it's just I know what it is, so I'm a lot more confused. But is this what is this? We're calling it the public right-of-way, but it's drawn on this Exhibit B like it's a independent piece of property. I mean, that's bound by the interstate wall coming back to touch Fairfax. It touches that piece of property. The right-of-way touches West End. That's what the piece. So I guess I just don't know, is it kind of merged into the interstate right-of-way? Is it its own piece of property? Do we know offhand? I'm just not sure why it was outlined on that.
So
In Bill's packet, Exhibit B.
yeah. And I'm looking at Exhibit 3 on my memorandum, and that is showing the condemnation or the acquisition of the property for the 440 right-of-way. And this property was cut out from that. I'm seeing prior lots, Lot 15, 16, and 17, that looked like they were condemned. It was the property of John U. Wilson or John V. Wilson. So it looks to me like in 1971 that the state took this property and it is now state TDOT owned property. I don't know if I can answer any better than that.
No, I think, okay, I mean, that's fair. I mean, that's fine. That gives me, I mean, I think I know how it came about. I was just saying that the state just owns property and it doesn't show up as a parcel that looked like that or whatnot. But, and I guess the other point was that in the packet that Fairfax, I guess at one point in time ran all the way to West End.
Correct.
And so the piece that touches of this property that touches Fairfax says that the building is in the shotgun-shaped lot it is facing what would have been the historic line that goes across. I mean, it just comes back however far it does from that line right
Right.
here.
Yeah, it was originally oriented to Fairfax, and then Fairfax was condemned by the state for right-of-way purposes, and all of that other 3 lots that were there was also condemned.
And if the argument, I mean, if it is believed that it really could face West End, then is it a buildable lot at all? It seems like that would completely, I mean, because it's a fairly narrow lot, it seems like it would be a very difficult, if not impossible, lot to build on if the long side of that.
True, that is correct.
Okay, any other questions for Mr. Herbert? We're getting close to 2 o'clock. Okay, if not.
Is there any evidence that that those lots were combined or the property was redefined at any point by the state? Or did they just buy them as, I mean, it looks as if the back portion of each of those lots maybe were, I can't really tell, but it looks like 15, 16, and 17 go through the property in question.
Yeah, I think that's correct, and I think this property was then cut out from the backside of those three properties, and the rest just remains as state property.
Okay.
If you look on Parcel Viewer, Metro's Parcel Viewer, it's just designated as state property. It doesn't give a name or anything else. It just shows property that was condemned.
Any other questions for Mr. Herbert? Okay, proceed.
I would like to go back to that parcel viewer view because it's very informative as to the right-of-way issue here. If you look at, and it's really Exhibit B on my statement that has the whole West End corridor detailed there, because this is taken straight from parcel viewer. What you have up there on the screen is also from there. And if you look at at the section that's zoned ORI, there's a block, and this section, the TDOT section that's part of the right-of-way, is included in the ORI zoning, just the same way that portions of 32nd, 33rd, and Orleans Avenue are included in the ORI zoning. This area is blank in the very same way that Orleans Avenue, West End Avenue, 33rd Avenue, 32nd Avenue, and Fairfax Avenue and Chesterfield Avenue are. It's part of the right, it's blank because it's part of the right-of-way, and it's part of the right-of-way for State Highway 1, West End Avenue. And so this property touches that right-of-way. It doesn't have a separate zoning. There's no parcel associated with it anymore. There's no, you can't, it's just been turned into the right-of-way. And so if the question starts with, does this property abut the right-of-way? The evidence that we have says, yes, it does abut the right-of-way. There's a distance between this property's line and the actual asphalt pavement. But as Mr. Herbert said, when he thinks of right-of-way, he thinks of sidewalk. There's very little distance between this property and the sidewalk. You can access this property from the sidewalk very easily. Now, the distance here is between this property and the actual black asphalt of West End is not that great. I went and measured it. It is less than the distance between where I park my car at the Kroger on the corner of 21st and Blair in our neighborhood and the front door of Kroger. So it takes less than 30 seconds to walk from, if you were dropped off by an Uber or Lyft or a private vehicle, to walk from West End to this property. It takes less than 5 seconds to ride your bicycle there.
How do you ride your bicycle? Do you ride it through the grass, or
It's on the sidewalk, because that's not part of the central business district, so.
But the sidewalk doesn't abut their property.
Pardon?
The sidewalk doesn't abut their property.
The sidewalk eventually does, and there are pictures that show that the sidewalk abuts their property, and I've got those pictures attached as part of my Exhibit A, and you can see, and it's where and actually you may be able to even. Let's see. But you can, let's see, you can see it in picture G1 and G2. Now, G1 is a picture that I took of the property from West End, showing where the construction's going on there, showing the signs, showing the appeal sign that I posted there. Showing where the contractor put his signs up there. You see the sidewalk there that passes by it, and then G2 gives you is from a different perspective. That shows how much it the property itself touches Fairfax Avenue. It's about the length of two of those green straws at the bottom. But it absolutely does. So,
I'm sorry, that was an existing, for some reason I thought that was alley, but I see it's sidewalk, thank you.
yeah, so I think the evidence that you have before you shows that the property abuts the right-of-way. Now, the right-of-way is not being used for black asphalt. And I think that's where some confusion might come in. But if you look at the picture that's up there behind you, the right-of-way for Fairfax includes green space between the sidewalk and the street. That's part of the right-of-way for Fairfax. You don't own, the property owners on Fairfax maintain that strip, but they don't own that strip. So if I were to walk from my house to the black asphalt on Fairfax, I actually have to cross either a sidewalk or grass. That's part of the Fairfax right-of-way. It's the same situation on West End. It's the same situation on 3209 West End, or 3205 or 3207, and on this property. You have to cross a sidewalk and some grass, or just stay on the sidewalk to access this property from West End. So, and this is important because if we are parsing the terms carefully, the terms have to mean what they mean. And the zoning administrator said that there was no vehicular access into this property from Fairfax. I think that's pretty much true. But he was referring, again, only to a personal motor vehicle that drives onto the property itself. But that's not what the code says. The code says vehicular access. And the code also says, and I don't mean to be cute about this, but it doesn't describe vehicular access in the way that Mr. Herbert found that it did. Because vehicular access to a property means that you can use a vehicle, whether it's a personal motor vehicle, a bus, a bicycle, which is by Metro Code a vehicle, and as a bicycle-friendly city, we need to acknowledge that. But all of those provide vehicular access to this abutting property, because it abuts the state right-of-way. That's the key thing. It abuts the state right-of-way. So all of that says that this property has, for this property, West End Avenue, under the code, is a street. And once once you apply the definition of street, then there's a street setback. Mr. Herbert suggested that there was something called a front setback in the code. I looked, I couldn't find front setback. I found frontage. I know this property fronts on West End. I found side setback, rear setback, and street setback.
I mean, there's no shortage of houses in this neighborhood that, you know, and I'm thinking of maybe or even around 12th Granny White on the property that the state owns for a cloverleaf that never got built, that are in the same situation that I think under your argument would be really facing the side of their yard instead of the street that they faced for their existence. And so, I mean, if we are swayed by the argument that this actually does abut West End, then why would it make sense for this to be facing West End when it historically faced, you know, the direction that it's facing? And logically, it looks like it should face, and I know it's law, not logic sometimes, but I guess I'm saying if that argument were bought, how does that then dictate that this lot is a lot to face West End and becoming the unbuildable lot that it appeared it would?
Well, I want to start off by answering the last part of your question first. It's not an unbuildable lot. if there's a street setback applied from West End. There was a building there that was before. This property was bought for $240,000. So there is a footprint on that lot that could be built that could yield a profit on a $240,000 lot in this area. So it doesn't become unbuildable. But I want to come back next to what you were talking about, I-440, because that's already addressed in the Metro Code. And specifically, it's addressed at 1736 380, which is the impact overlay district for West End. And it's not part of my materials, but I would like to read it because it applies to those houses that you were talking about over on 12th Avenue, and it applies to this lot and the way that the zoning policy should be applied to this lot. And that says, zoning policy, and this is from 1736 381. And this is in Impact Area 1B, but this applies to all of Impact Area 1, which includes the 12th Avenue South area that you're talking about. This is the sentence. Zoning policy should be to vigorously support the preservation and protection of the existing stable housing and neighborhoods adjoining the Interstate 440 corridor, with particular emphasis on areas presently zoned for one-family and two-family type housing. So when you're looking at how you interpret zoning policy in areas that are affected by 440, it's got to be to vigorously support, that's what the code says, vigorously support the preservation and protection of the existing stable housing and neighborhoods. So that's what we're asking you to do, is to vigorously support our single-family neighborhood that's attached to it. And as to whether or not it's unbuildable, we go down to Section 3 of 1736 380. And that says, and this would be perfect for this property. And our neighborhood has worked with groups exactly for this type of thing. It says, Plan Unit Development Overlay Zoning provides the best opportunity to address site design, buffering, traffic access, and other development considerations that may be of concern to adjoining property. Generally, PUD overlay zoning should be used in order to achieve a harmonious relationship among new and existing development. That's what should have been done here. There should have been a development of a PUD in accordance with 1736 380. 3. But coming back to 1, what happens because the state bought this land and never used it for 440, but it's part of the state right-of-way for West End, is that you've got to use zoning policy to vigorously support the preservation and protection of existing stable housing and neighborhoods, like the one that you see on Fairfax and Chesterfield right there. So that's, and the one over on 12 South. So those properties are zoned differently than this. This is ORI zoning with, for high-intensity uses with little setback, where they're proposing to put on this 8,200, it's like a fifth of an acre lot. They're putting 21 units in a development that is going to dwarf the houses down the street. So it's a sea change from the existing stable single-family neighborhood that is right across the alley from it.
So going back to the parcel argument, if it by your definition abuts West End, why is West End the frontage and not Fairfax?
No, it's not a question of, well, there are two reasons. One, it's not a question of whether it's a frontage or not. It's whether you apply a street setback on West End. And that's why if a street back should be applied as to West End. That's number one. But number two,
As a side setback or a rear setback?
as a street setback.
So a front setback is
Well, the code says street setback.
So
I
you're
don't-
arguing it's a corner lot?
No, it's probably closer
Well,
to
if it's
being.
abutted by two streets, it's a corner lot, right?
Yeah, well, it's more likely like a through lot, but it's got it abuts two streets.
So then how do you choose which street is the street setback?
Well, you have to apply, the code doesn't say you choose. This code says.
But you are.
I guess,
You're saying you choose, and I just want to know why you choose. Why
Well-
you've chosen what you've chosen. Is it because,
Well, if I may, I would like to answer your question. I'd like to use
Sure.
some of the drawings that they have.
Can you bring it back over to the microphone so the folks on the Metro Nashville Network can hear you?
Yes. Okay, so in terms of what's the front of the building, what's the front of this proposed development? This is the view from West End. Okay?
well, that's not exactly what I asked. I asked,
Okay.
how do you determine what the front of this building is? Or how do you determine what the front of the property is? The zoning administrator presumably doesn't care which way the building faces. He's concerned with what he's calling the street. So how do you pick West End over Fairfax?
Well, I go to the definition in the code of what frontage and front facade mean, starting off. And frontage means any portion of a lot that abuts a public street, excluding alleys, and, quote, open space. Front facade, or frontage principle, means the frontage of highest pedestrian importance. Front facade, and this is the important part, front facade means the front vertical face of a building that is substantially in one plane, has associated with it a primary entrance, and is composed from the following architectural components: exterior walls, columns, or other vertical structural elements, windows, doors, roof edges, permanently roofed recesses, and arcades, balconies, or porches with permanent roofs supported by vertical structural supports. That's the front facade. And I want to contrast a couple of things here. One is this drawing right here. This has almost all of the elements of a front facade that I just
But this is
described.
proposed. We're not talking about what's proposed right now. We're talking about what is in front of us and what the zoning administrator did not use that picture when he determined this case. This is an item A case, and we're trying to decide whether the zoning administrator is correct. So by showing the pictures from the other side, which I'm sure Mr. Herbert did not see or did not use in his opinion, that doesn't do anything for us trying to determine if he was right or wrong, because he didn't use those.
Well, the question is, sir, Mr. Chairman, I believe that the site drawings and plans were submitted to Mr. Herbert and were present there when there was the issuance of the building permit. And
But the pictures that you're holding up, were those submitted?
not those pictures, but let's see, there was, let's see.
Let me ask you,
There was this site plan that was submitted.
It's different from what you were holding up and trying to make an argument to us about. Like I said, we're here for an item A case, and if that wasn't used to determine what Mr. Herbert wrote, I don't think that's relevant to your argument, because we're here to determine whether he was right or wrong, and if he didn't use those pictures based on his argument or letter, it's irrelevant.
Well, he did use the site plan that was submitted and attached. So
Well, then let's
so
talk
let me
about
just-
that, and
Let's
then you
just
could-
talk about that.
yes.
So let's just talk about that.
let me ask you something.
Yes, sir.
Can anyone build on the right-of-way?
Build on the right-of-way?
Yes.
No.
So that's a non-buildable lot, correct?
Well, the area, but yes. It's a non-buildable lot. Nothing can be constructed there. It belongs to the state. It's part of the right-of-way for West End Avenue, US 70, State Highway 1.
But the state could develop it as they choose. I mean, they could put something there, or
It's part of the, I think that would take a lot of work because it's part of the right-of-way. So I'm not sure, I mean, what they would do it for.
Let's get back to the
come
item
back
A
to-
appeal. So I'm going
okay.
to ask you the softball question. I'll ask Mr. White the opposite. Why did the zoning administrator err in his ruling on your case? Tell us.
Because when he determined that the property, that West End Avenue was not a street for this property, that was an error. When he determined that the property fronted on Fairfax, that was in error, because the property does abut the West End Avenue right-of-way, and in his opinion, we have this drawing right here. And we believe that the property abuts West End Avenue, touches the West End Avenue right-of-way, and so West End is a street for those purposes. And the reason why it should be the front, West End should be the front, is because of this drawing right here, for this building permit. And if you look at this drawing that was submitted to the building permit, there is one facade in one plane that is presenting to West End. There is nothing but a tiny little point that presents towards Fairfax. So the property, we know that the property does not front on an alley, because he said, because it can't. So we know that the property can't front on the alley, but we look for things for the front vertical face of a building substantially in one plane that has the architectural elements that I ran through, and it is on this, it is all along here on West End. That was the best determination of what the front of this would be, because the building itself, towards this 22.5 inches that it abuts Fairfax, is only the point of a triangle. That's not a vertical face of a building substantially in one plane. So what we see is what fronts towards Fairfax. I mean, not towards Fairfax, towards West End. So that's where the front of the building is. That's where the error was made in issuing this building permit, because that's what we're appealing.
So,
and
I've got a question. Do you know of any time in the history of this property that it was had any other address than 206 Fairfax?
No,
And then-
because what happened was with this property is this property was previously the three lots. There was a gas station in what is now the state right-of-way, and this property and Fairfax went all the way through to West End. When this property, when the state put in 440 and acquired the right-of-way, and this is the other thing that was missing, and I want to call your attention specifically to this, because it goes directly to access, and whether or not this property should be called, whether it's Fairfax or West End. When the state acquired part of this lot that's at issue in 1973. And that's the deed that I have at Exhibit D in our materials. And there's something that is important from that deed that it says that all rights of ingress and egress to, from, and across the same, and to and from abutting lands is hereby conveyed. And what they conveyed was that strip of this property that, for almost all of the property that touched Fairfax, except for the 22.5 inches. It was about 450 square feet, but it's why this property is lopped off. They lopped off the access to the Fairfax right-of-way and said you can't cross the Fairfax right-of-way anymore. And so that's why you can't say that there's access. They've given away, or a predecessor in title to these owners gave away the right to access the Fairfax Avenue right-of-way.
But if I guess the question is, why wouldn't it, at that point, have a West End address instead of a Fairfax address? It kept its Fairfax address when that happened because no one thought it wasn't on Fairfax, maybe, or not.
People don't like to change addresses. I don't know. I mean, there are Fairfax Avenue addresses that are on the other side of West End still, over on the other side of the MAPCO. There are properties there that still say Fairfax on them, and they're nowhere near Fairfax. But when I know that because I've lived in that neighborhood since 1985, and that's the way we would go by bicycle to get to our Little League games. So we would go through, go down this sidewalk, go across, and there's a little stub over there behind the MAPCO, behind the coffee shop. That there's a couple of places that have a Fairfax Avenue address.
Okay.
They're not on Fairfax.
Right.
That's not Fairfax Avenue?
If it is, I don't see it as.
It is.
It is?
Yes, because it was cut off from the
Okay.
interstate.
Yeah, however they did it, but how they didn't, I don't know why they didn't rename it. I don't think that's not an element that the code puts on the property for whether or not it fronts on a street as what's the municipal address for it, or what's the post office address for it.
Yeah, I just haven't seen I haven't seen a property where the address was the short side of a street and they were trying to argue this.
Well,
It's an unusual case, is what I'm saying.
Yeah, there was a property where, on the corner of Whitland and Wilson, where they did an alteration to their house so that they could have a Whitland address, and that was. That was a few years ago, but they changed, they did something architecturally to the house and changed it so they would have a Whitland address rather than a Wilson Boulevard address so they could get a higher property value, I believe. But I do know that happened. So, but the street address isn't one of the elements that we consider in looking at the code and looking at what the front of the building is, what the frontage is, what the front facade is, whether or not it abuts a public street. So that's okay. So,
Can I ask one question quickly? I know you're getting into your time, but I'm still troubled by your definition of abutting, and I'm looking at Exhibit 7 to Mr. Herbert's materials because it contains the definitions. You may have it another place. But I understand your argument is because the only thing between West End and this subject property is a right-of-way, it essentially touches West End. That's what I understand your argument to be as to the abutting West End.
No, ma'am. My argument is that the property is part of the West End right-of-way. It's not. It is part of the West End State Highway 1 right-of-way. It belongs to the state, just like the rest of the right-of-way on West End.
But the subject property that we're talking about, it still has to abut the street, correct?
Well, no, it only has to abut the property, not the street itself, not the black asphalt on the
Well,
street.
I mean, that's where I think I'm getting confused. And so maybe you can explain it for me with an example. I look at the definition of abutting, and it says, this term shall not be deemed to include parcels that are across a public way from each other. So what does that mean
Well,
by way of analysis?
by way of analysis, this property would not abut, if I can, the house across the alley from it. Okay? Because the alley is a public way. And so you don't abut property, it doesn't abut, it abuts the Continental, because the Continental is right there. The two property lines touch. It does not abut 208 Fairfax, because there's an alley there. So my property abuts 305 Fairfax and 309 Fairfax, because I live at 307. It does not abut 306 Fairfax. That's just across the street, even though there's a public right-of-way in between us.
Okay.
So that's what.
So the common point or line that this property shares with West End is which line?
It is
Just the line of the property itself?
It's the property line itself,
Okay,
right.
so you're
It's
saying
that 100
essentially that is West End, all the way up to that property?
That's the West End right-of-way. It's 155.3 feet that it touches
Okay.
what is legally part of State Highway 1, the right-of-way for State Highway 1. It is the blank space on that map, just like Orleans or West End, or the rest of West End. If you look at that map that's behind you, which there's no like little parcel line that blocks off this area from the rest of West End. There is a line that blocks off I-440, but there's not a line that, lists 440. You've got the lines for 440 there. But there's no line there that separates this from the West End Avenue right-of-way. And you can see, if you're, it's exhibit, I think it was Exhibit 1 to Mr. Herbert's letter. You can see that there's other blank space that's part of 440 that's zoned RS 7.5. That's all right-of-way. Fairfax Avenue, you can see on Exhibit 1, you see the right-of-way for Fairfax Avenue. You see the white material that, this is on Bill Herbert's Exhibit 1, you see the white material that is the black asphalt of Fairfax, and then you see the dotted area that's still part of the right-of-way for Fairfax that doesn't belong to those properties. So every one of these properties along Fairfax, other than 206, if we look at 208 and up, all of them abut the Fairfax right-of-way, even though you have to walk across the sidewalk and grass to get to the black asphalt of Fairfax. And that's the same as this property. You have to walk across the sidewalk or grass on the sidewalk to get to the black asphalt of West End, but it's still part of the West End right-of-way. It still abuts or touches the West End right-of-way. And that's the reading of the code that makes sense. It's in accordance with the words, and it's the literal words, and it's in accordance with the I-440 impact statement that I read earlier that governs how zoning policies is applied in this area that was in place long before these folks bought this property. And so So that's why we believe it abuts West End Avenue, State Highway 1, US Highway 70. Okay, all right. Now, I'm not sure how much of my time, does that
So
include?
that is your total time?
You may want to reserve the remainder for either other people who wish to speak in
Yeah,
support of your
does that
claim.
include the 3 minutes that?
Yes, it does.
Okay, so I'm going to.
You're at the nub. You're probably good.
All right, so I'm going to, there are some other neighbors here, part of the Hillsborough West End Neighborhood
So
Association.
here's the issue.
Yeah,
You're giving them basically 1 minute and 21 seconds to speak because you wanted 3 minutes for a rebuttal.
right.
So anyone that comes up here cumulatively, you have 1 minute and 21 seconds.
Everyone who would stand up is going, and if I could, if I could, in the interest of making this, moving this along, because I know there are a lot, I heard all the voices behind me just a moment ago, because we've taken a fair amount of the board's time. If I could just bring up some of the neighbors and then just have them very quickly say simply whether or not they believe that this building permit would be supportive of the single-family housing neighborhood that where the traffic is coming.
Okay? If they could do that in 1 minute and 21 seconds, if they go over, they're cutting in your time, okay?
Right. Okay.
Hey, I'm Tom Cash. I'm the Vice Chair of Hillsborough West End Neighbors. We've received a lot of communication about this project, and I can tell you that in almost every case that they do not feel that it is supportive to the existing housing along Fairfax and Chesterfield, and we encourage you to vote in favor of our appeal.
Hello, my name is Martha Stinson, and I'm president of the organization. And we would encourage you to vote in favor of the appeal because the property brings all of its traffic down our neighborhood streets, and it impacts the interior of the neighborhood, which is against Nashville Next.
Can we just get a show of hands as to who supports this request?
Supports the appeal?
Your side. And the other side, let's show of hands on the other side. Okay?
I'm not sure that those folks are neighbors, not all those who raised
I
their hands
didn't
were
ask for,
neighbors.
I just said
Yeah,
who has spent now going on almost, an hour and a half of their time to come here. And they're citizens of this state, I'm sure, and most likely citizens of Nashville. They care enough to be down here.
All right.
Okay?
All right. I'd like to reserve then the rest of my time for.
Okay.
Did you want to say? Reserve the rest of my time.
John Michael, we have a request. Is that, like a brief 5-minute, 3 minutes recess?
Comfort break for the board. We'll reconvene shortly. Appellant will now hear from the opponents to that case. The developers are represented by Mr. White of Tuninterkin & White. Mr. White, if you wish to come forward, you too will have a magical 15 minutes. Feel free to introduce yourself and begin with your presentation.
Thank you. I'll listen closely to 15 minutes. I like that. Mr. Chairman, members of the board, my name is Tom White, 315 Dedrick Street, and I represent the property owners in this case. I will, at the front end, address the short history here. Jared Bradley's to my right. He's the architect for the project. Dr. Truett Ellis is one of the two partners. We'll be sitting here at my left shortly, but to keep this moving. The history of the matter is this. No one has questioned the ORI zoning on this property. The ORI zoning on this property allows exactly what my client's doing on the property. It allows actually up to 65 feet. They could have built 4 levels and 28 units. They built and are in the process of construction of 3 levels, 21 units. No one's going to argue that's not the appropriate use here. It's next to an 11-story continental development. It's basically in the area that you're seeing on this map. With respect to the history, The client came down long before I was involved, turned in all the papers, engineers, architects. They were issued the permits for the project. It was very simple. They moved forward. At some point, an issue was raised about the only issue here today, which is straight setback. When that issue came up, the zoning administrator and other people contacted the client. The client contacted me. We came down. There were several meetings with the council lady, several meetings with Bill Herbert, and the client voluntarily discontinued active work on the site for a period of approximately 30 days. Till we vetted everything. Bill Herbert then did the Item A case, which is before you today, which is about the most thorough Item A case I've seen for many, many years. Sonny West, Bill Herbert, they don't always have the time to give a detailed Item A case. They did here because there was enough time and involvement, enough visits had taken place, and it's very clear in its opinion. Now, with respect to the goal, if I could get the other map put up here, John Michael, with respect to the goal, here's exactly what the issue is. If you have West End or the alley, either one, deemed as the front of the property, it basically emasculates the site. That's the whole goal. The site is 50 feet wide. The prior use, somebody made the comment the prior use was consistent. It wasn't. It was a 30 by 6 daycare. This site, if you took 20 feet off one setback, 10 feet off the other, it's a 20 feet strip right down the center. They've condemned the property. That's exactly what the goal is here. Now, with respect to the opinions that have taken place, I want to read exactly what the zoning ordinance says. Street setback is the critical language. It means a setback extending the full length of the lot line abutting a street. What did Mr. Herbert say at the front end? Two key words, quote, abutting a street and street setback. There is no other street that has access to the site or that it abuts other than Fairfax, period. Now, in Mr. Herbert's opinion, which again was detailed, you all have had a chance to look at that, but he cites exactly what I just did. Under the code, street setbacks means a setback extending along the full line of the lot line abutting a street. He goes into exactly what the code says, and that's exactly what he interpreted. He then made the second point, which he did today with his board, and said, historically, the southwest lot line of the subject property has been determined to be the front. And historically, he covers the fact that he even went back and checked through the Metro property assessors to see what it was, quote, and the 1973 deed declares the lot line abutting Fairfax to be the front. Now, I don't think it could be any clearer in the definitions, and I'll read here for just a minute. Opposing counsel said, let's everybody look for just a minute at a 1973 deed, which is Exhibit D to one of his filings. And he makes a comment about that particular deed. This is after the remnant piece. John Micah, if you'll put up the little map up there, please. This is after all the frontage on West End was taken off. You were looking at the piece that's in red up there. But the state came back and they acquired a little sliver of property, 450 feet. And I want you to look at Exhibit D for just a minute and see what the state said in 1973. Look at the second page. This property is improved and is located on Fairfax Avenue, 200 feet southeast of West End Avenue in Nashville. It can't be any clearer. Everybody referenced Fairfax as the street setback for this piece of property. Now, with respect to other items, again, I don't know how somebody can credibly argue before this commission that there's vehicular access off of West End in this case. As an example, what if you had a railroad right-of-way, active or inactive? Would you leap over that and say, oh, by the way, even though there's a right-of-way and everybody concedes this is a clear state right-of-way, if you look at the map, there's a clear, large piece of property between our track and West End, period. It's a separate piece of property. How can somebody argue that we are abutting West End with that type of fact? It's incredulous. Now, with respect to the issues about neighborhood and involvement, you've seen who came down here to this hearing. There's vast, overwhelming number of people that have raised their hands that are supportive of our position. That's not the litmus test for this group. But if you look at some of the letters that were written down here, and there are, and the staff will confirm this, there's more than 20 letters down here in support of my client's position. And very quickly, some of those letters I think are so telling. The first one is from representatives of Continental, the 11-story next door. I haven't seen one communication from them that isn't totally supportive. Their comments, this is letter number 2 of the 20 that I've seen down here. I attended a meeting at the Continental with Berkeley Allen and leaders of HWEN where the developers explained the project in more detail. Based on the project plan and the architect's sketches, I think it's an attractive improvement that will provide curb appeal and value that the prior structure lacked. Now, mind you, the prior use here was not only 30 by 60, it was a daycare center where they had 7 employees and 33 to 35 students every day, all peak time, because of the nature of that operation. Letter number 5 is from a resident on Fairfax. I live and own a home on Fairfax Avenue, only a few doors down from 206. I support the proposal of my client. I believe some increased density is appropriate at the fringes of the neighborhood. Again, no one's questioned this ORI where you could have 65 feet and 28 units. I value the historical West End neighborhood, but given the challenges we face with both growth and historical preservation, I don't believe that opposing this project is an appropriate use of the neighborhood association's time, focus, or resources. I think you just saw that resoundingly from what you saw here with a show of hands. Further, in my experience, some of my neighbors who are in opposition to this project are often intentionally difficult, don't respect individual homeowner or property rights, and frequently promote their own individual interests at all costs. I think that's what we heard from the mic. There's another letter, which is number 13, another resident of Fairfax. I'm an owner on Fairfax. I support this proposal. The location is between an interstate exit and a large condominium building at the fringe of my neighborhood. This is an appropriate location for increased density, and the planning use is more appropriate than was previously there. Intentionally creating an underutilized or inappropriately utilized parcel here hardly seems like good land use policy given Nashville's challenges with growth. I have confidence the developer of this project cares about the opinion of other neighbors, and this would be a reasonable proposal. Now, I didn't prepare these letters. They were 20 of them plus turned in here. That's the general sentiment. It's not a popularity contest here today, but you need to understand the sentiment of folks that are there. The whole key is, what's the terminology? Street setback and abutting a street. It can't be any other way than what the zoning administrator gave his opinion about. I'll make a few comments and turn it over to Truett Ellis here. That is, let's remember, the burden of proof in this case is on the opposing side. They've got to show you that they are right in this matter. That burden of proof is not on us. Also, a general context of land use law is that any interpretation here should benefit my client. It should be construed in favor of the property owner, period. Again, some of the definitions that have been read, if this site has got vehicular access, someone on this group just said then basically every piece of property in Nashville has got, quote, vehicular access to West End. Every place around where you've got TDOT remnants all over the place, can you imagine those people coming before this board and saying, oh, I don't have access on my side street or my front street, I'm accessing whatever. It makes absolutely no sense. The other thing that I'll comment about is that with respect to TDOT for just a moment, look at the map. There is a very significant TDOT right-of-way between us and West End. It's another parcel. How can anybody credibly argue that they are abutting West End here? It makes no sense. I appreciate your courtesies. I'd like Dr. Ellis to make a few comments. Thank you.
My partner and I bought the property in 2000.
Please,
Truett Ellis, owner of 206 Fairfax. My partner and I bought the property in 2011. He lives around the corner on Hillside in the neighborhood. I don't live far. I've lived on Fairfax in the past. It had been a daycare at the time. It was Darlene's Little Angels. I worked with Darlene from 2011 until she wanted to retire and wanted to be let out of her lease in 2015. And we knew we'd wanted to have improved it. It had been, Darlene had been there since the 80s. Her license was for 30 or 34 children. She had 7 employees. We didn't think the building was dilapidated. We didn't think that certainly fit in with the neighborhood character. We felt like, given the prices, we're local and we were patient, given the price that we got on the property, we could leverage that into outcompeting some of the competition in terms of cost for new construction for apartments in Nashville. And so we thought we could deliver a stylish building and at a really, really competitive price for new construction. Shortly after tearing the building down, we were asked to stop. We spent a month meeting with the zoning administrator. We were asked by the council person to investigate the affordable housing pilot project out of the mayor's office. We immediately turned in an application. That was to try to demonstrate that we were willing to listen, engage, take suggestions, and we also thought that kind of went with the spirit of the project. Then we proceeded after that month, and we got the item A appeal. We did try to reach out about community improvements to maybe scoot the building a little bit closer to the Continental and a little bit further from Fairfax. We hope that would lead to some dialogue. That never developed. It's always been sort of a contention that maybe it should be a really skinny building or not buildable. By the time the item A appeal was applied, it was very difficult to either it was going to disrupt the pricing on my contract pricing, it was going to disrupt my financing, it was going to put the property in jeopardy. So we went ahead with construction. I've got pictures of where we are today, and I can answer any questions.
Mr. Chairman, to my right is Jared Bradley, the architect for the project. Before he comments, I want to read another item that came into the record today. This is from Rory Rowan, who's with Metro Public Works. In my position at Public Works, I've had significant involvement with the site. I'm familiar with the condition of the site when it was formerly occupied as a daycare center. I've been in touch with the current owners of the property who are building the 21-story unit apartment, Council Lady Berkeley Allen, and a number of individuals in the neighborhood. The current owners have been extremely cooperative and responsive to suggestions from my department. The current use on the property with the incorporation of our suggestions makes this site a better site in terms of traffic flow and parking than the prior use on the site and should be compatible with the neighborhood. Thank you. This is Jared Bradley, the architect.
I should have taken that speed course in speaking. I just want to hit a couple of important elements on design. From the onset of the project, we've always viewed Fairfax as, from an architectural perspective, as the front. We've never looked at it any other way. We have to apply both the law and logic. So, and in this case, from the beginning, we used our logic, which is what's best for the community in this case, in the neighborhood. I'd also like to quickly address mass and scale. As you can see, we are working from an 11-story building down to basically a 3-story housing, which is approximately 34 feet once you count the roofing of the adjacent houses. So we're going down from 11 stories to 3 stories over parking, which we feel is more than ample in terms of kind of stepping down into the neighborhood fabric. And then I'd also like to say that I think I brought the renderings up front to show you how we're addressing front. And if you read the code, the primary entrance is from the Fairfax side with the sidewalk, the gate. We have our primary wall, which is consistent all the way up the front. We have basically, when you enter the site, you go into the main gate through the landscape area, through the sidewalk, and you're at the elevator lobby. The main elevator lobby is right on Fairfax, as is the main stairway. Our secondary means of egress is in the back opposite side of the site. So we feel that we are absolutely conforming to the definition of front, and that we're absolutely conforming to the requirements that we feel are necessary for mass and scale. And I'll answer any questions that you might have.
Mr. Chairman, the next witness is Cheryl Rogers.
Hi, I'm Cheryl Rogers. I'm a resident of 304 Fairfax. I've been there 20 years. I'm a single mom with 2 small children, ages 8 and 11. They went to and go to Aiken Elementary, and we like to ride our bikes a lot. And there's a lot of traffic at the end of that street already. The most traffic there was when that daycare was there, and people rushing to get their kids and rushing to drop them off and then get to work. I'm hoping that with this property, I sat down with the developers for more than an hour where they answered my questions, and I left with them not even knowing where I fell on this. And then I went to the small community meeting that I understand they didn't even have to have, and heard what they were planning to do with traffic, how they were planning to work with the Continental on traffic. Traffic's a big thing to me because I don't want my kids on their bikes being hit by all those people rushing to the daycare. So with it being housing, I find myself coming and going different times during the day. I find myself seeing other neighbors who are also coming and going. There's less of a peak time when people actually live on the street, in my opinion. That's what I've seen after 20 years of being there. Is I'm excited about the improvement for the neighborhood, and I think it'll be a great development, and I'm in support of the development.
Mr. White, you have 43 seconds left.
Next witness.
Hello, my name is Scott Chambers, and I live in the HWN neighborhood, and I'm a past board member there as well, and I'm here in favor of the project. I don't think there's ever been any question about the zoning, and what is being built is as of right, and I think it's very appropriate that we are nominally increasing the density there, given what we all know to be our mass transit needs. And the proximity of this to West End, I think, is very appropriate to help support future mass transit.
Mr. Chairman, in closing, I'm sorry. Go. In closing, I'll just make the comment, we're here on an item A appeal, burden proof on the other side. The logic and the rationale can't be any clearer than that what Bill Herbert spelled out. You cannot look at street setback quote, on the full length of the lot line abutting a street, and look at the definition of abutting and have any possible other conclusion. Thank you.
Okay, time's up. I will ask you the same softball question that I asked the other side. Why is the zoning administrator correct in his ruling?
I think, Chairman Ewing, the zoning administrator is correct because he, like all of us, have to deal with the definitions that are in the zoning ordinance. We can't get creative and make things up. And he said two things. He said, I look at the language, which he did at some length. As I've said, all of us have been here many times where a zoning administrator does something on the fly almost because they're pushed for time. It doesn't make it any more correct or incorrect, but here's a time where the zoning administrator had a good deal of time, did a very thorough exhibit list, and my comment in response to you is that he said two things. Please look at the language. Street setback means a setback extending the full length of the lot line abutting a street. His comment, there's only one street, period. Secondly, the word abutting. The abutting doesn't mean you jump over a state piece of property or a railroad right-of-way or something else. You abut it. Nobody can sit here and tell you that this parcel abuts West End. It's just incredulous. That was his comment. But before he left, he was asked several questions by this group, and he kept coming back to two things, and that is the definition of street setback and abutting a street, both of which are absolutely totally controlling. That, coupled with the fact that he is aware that the burden of proof is on the opposition here, in my opinion, is absolutely totally controlling. And again, I just don't think there's any other possible interpretation other than somebody trying to emasculate the site. And if you do, how can you disagree with the fact that if there's 20 feet left right down the center, Metro has condemned this property, period. That's it. And that was what Mr. Herbert said. And again, I'm not going to go through his entire 2- and 3-page presentation, but it was extremely thorough, had every exhibit. And as I said, he referenced that Exhibit D to Mr. Prochaska's brief, where that brief says it is, quote, I thought that was so telling. I don't know why our opponent cited that particular item, but that 1973 deed from the Wilsons was absolutely clear about the fact that in 1973, the state picked up that last little remnant, and they said the address is 206 Fairfax, 200 feet plus away. So the state owns the property. Think about this. The state could fence that property. The state could sell that property. You know, they've got mechanisms for the state. That's how the Metro acquired in part where the new Sound Stadium is right now. They can sell property. So if that argument is correct by our adversary, it ignores all the facts and it basically gives a totally incredulous opinion of what street setback and abutting means. It can't be anything other than what we've argued here. And that's what your zoning administrator said, who has a long history with this board and a land use background that's very good.
Okay, any questions for this side? Nope. Okay, let's hear from, will the rebuttal 3-minute period? Or what was the time? 3:47. Okay, come back forward.
There's, let's see, a couple of things just on rebuttal. One is that this property, well, it abuts the right-of-way. When you look at the definition, it abuts the right-of-way of West End. And I think we exhaustively explored that, but there's nothing between this property's lot line and, well, it is just simply West End Avenue there, State Highway 1. It's the state right-of-way. Let's see. Did you? The one thing that I want to spend a little more time on is the zoning policy that applies to the I-440 impact area and what this would do with regard to the neighboring single-family neighborhood. And it's not a question of what this development versus what previously existed there. It's a question of what the permit should be going forward. And it's a question of whether we want to have additional traffic coming down this street for a property that is part of the West End ORI zoning corridor. And the I-440 impact statement says you've got to use the zoning policy to support the single-family residences behind it. I know it's not a popularity contest, but there was a number of neighbors who live in the area that would be affected by this property, who are the aggrieved parties from the permit area with the neighborhood association. And I'd like to have a little more time given to our neighbors, the people who actually live in the neighborhood, to talk about the impact of this traffic and this development on the neighborhood. So I defer to our neighborhood president, Martha Stinson.
Thank you. I guess the problem I have with the property and the development is that it's considered to have a street setback on Fairfax, yet it is zoned as though it's on West End corridor. It is treated in Nashville Next as though it's on the West End corridor. And the difference in the fact that the Fairfax actually is a dead-end street, a small, narrow residential street deep inside our neighborhood. We have a historic neighborhood. It's got a lot of historic character, and the fact is that it's zoned RS, so it's single family. So this multi-unit development, which is going to use our neighborhood street and bring the traffic legally, the legal ingress and egress is down through the interior, deep interior of the neighborhood to this multi-unit development. So it looks like it's on the corridor and it looks like a corridor development, but the impact is tremendous and detrimental to the neighborhood, which is supposed to be protected according to Nashville Next, with the way Nashville Next has treated and designated the historic neighborhood, and with the separate way that it has treated and designated the West End right-of-way.
9 seconds.
I'd also point out that the setback that the daycare center had, it was farther back, so the new building does not conform to the same setbacks that the other properties on Fairfax do.
Okay. Questions for the group? Okay. Seeing none, and last but not least, we have the twice duly elected council member from this district, Berkeley Allen. Welcome, Council Lady Allen.
Thank you very much for the opportunity to speak. I will be brief. I know we've heard this a lot. I certainly appreciate the very thorough vetting y'all have given to this subject. This project was brought to my attention in 2015, and at the time, Mr. Ellis wasn't entirely sure what he wanted to do. He knew he wanted to do multifamily. At that point, he mentioned 12 to 13 units, and I agreed that according to Nashville Next, we want to put the density on the corridors, and it makes sense to have it there. He then went to his architect, who looked at the highest and best use, as architects always do, based on the setbacks that we have that we've heard about. And the reason this is relevant as a setback issue is that how that the buildable area of the lot determines how many units can actually be there, and how many units can actually be there affect the traffic and the parking. In the community meeting that we had last week, which actually was a great meeting, a lot of great communication, what became clear was the issues of concern here are really about the traffic and parking this will generate. How do we deal with it? My hope was, through allowing this appeal to be made, that we would have incentive to work toward a compromise of perhaps having fewer units. At one point, this actually had been drawn so that it was 10 feet from the Continental and 20 feet back from Fairfax mistakenly. And at the time that was corrected, my hope was that the architect would choose to maybe shorten the building and diminish the number of units at some point. They chose to move the building forward 10 feet further, which resulted in having to move electric lines that were in the way. There were opportunities to lessen the impact on the neighborhood not taken. And I understand financial concerns. Actually, I know I don't understand them. They're very complex, and I know that they always figure into that. My hope is, regardless of your determination here, I'm not a lawyer. I can't speak to the fancy legalese of this. I do think it's important that this project have as minimal impact on the neighborhood from a traffic and parking standpoint. If that can be achieved by reducing the number of units, which I think might happen from a conversation that would continue as a result of this appeal, that would be one way to do it. If not, I will pledge to continue to work to make the impact of the traffic and parking from this project be minimal on the neighborhood. Again, I appreciate the conversations that I had with Mr. Ellis, with Mr. White, with the neighbors. We've all worked really hard at how to make this interesting orphan property that is zoned RI at the end of a dead-end RS street work. We will do it one way or another. If we can do it by making it smaller, that's great. If not, we'll work with other things. I would again acknowledge the good conversation that we had. The topics that we talked about were traffic and parking. I appreciate Mr. Ellis looking into the HIP, and I hope he will continue with that. And the other issue we talked about was short-term rental not being allowed. That was a great conversation. We didn't get to any official compromise at that point. I'm glad we had that conversation. I'm going to leave this in your hands, but I want us to keep working on making sure this project is good for all the neighbors, those that support it and those that are concerned about the traffic and parking. Thank you.
And any questions for Councilor Allen?
Thank you.
Okay, thank you. John Michael, let's close the public hearing unless there's anyone else to hear from. Nope. Okay. Board members, as we are always reminded, this is an item A case, so we are here to determine whether the zoning administrator, Bill Herbert, was correct or incorrect in his ruling on this particular piece of property. Discussion.
Well, I'd like to start out first by saying I think we had great presentations today from both sides and from our zoning administrator. We always get really good speakers here today, and I'm always so impressed by the non-lawyers especially, who are so articulate and passionate about what they have to say. I think we had a big packet of information that we all reviewed prior to the hearing today, but the oral arguments still add to that. I would have to say, for purposes of starting the conversation, I did not hear anything that made me think the zoning administrator erred. He wrote a detailed, thoughtful, lengthy analysis compared to what normally has to happen in these item A's, and I would be comfortable upholding his position.
More discussion.
I tend to agree, and I think that there are an awful lot of important issues that were raised that relate to its OR zoning and density that do impact the neighborhood, but don't relate to the decisions the zoning administrator had to make. And that is often the case with some of the cases that we see, that the impact is outside of our purview. But I think when we ask the question, was the zoning administrator in error, or did he act arbitrarily? I didn't see anything that said that he should be overturned.
Anyone else?
I concur. He spent a great amount of time in detail, and I appreciate the letter that he written.
I appreciate Councilmember Allen saying that she's trying very hard to work with both sides here. I hope that will continue to happen. I do appreciate what Nashville Next asks us to do to maintain neighborhoods, especially historical neighborhoods in our city. Our pains of growth are evident everywhere we look, and here's another one. I had a particularly difficult time understanding how anything can abut a street when there's only 22 feet there. That's really bothering me. So this case is very difficult.
Did you mean 22 inches?
I'm sorry, I misspoke. I meant 20.
Anyone want to have a motion?
I'll move that we find that the zoning administrator did not err in his opinion on this case.
Okay, motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor of the motion upholding the opinion of the zoning administrator, say aye. Aye. Opposed? Passes unanimously.
The item A appeal is defeated. That concludes case 181. We can move forward to the next case or take a brief break to allow the room to clear before taking up case number 156, Mr. Chairman. We'll take a brief moment just so that everybody can clear the room. And take up the next of its cases. We do not necessarily anticipate that the remaining 9 cases will take 2 hours each, but we need to be prepared for that just in case. Mr. Chairman, with your permission.
Is it Monday yet? Is it Monday yet?
We're all right.
Mr. Chairman, with your permission, we'll go ahead and begin the presentation of case number 156. Case number 156 is involving the property at 2317 Pennington Bend Road. The appellant is Mr. Adam Epstein, represented by Baker Donaldson attorney Joey Hargis. Property owner is Ms. Carol Anderson. The request is for a variance from front setback requirements. The original filing also included a request for side setback requirements, but the appellants have decided to meet the zoning code requirements for side setbacks. Therefore, the only question before the board today regards the street setback requirements. The presentation is brief, shown here on the zoning map. This is property along Pennington Bend, right at the river. The aerial gives you a view of the proximity of the subject properties. It's actually 3 thin lots right up on the river. Site plan submitted gives a simple concept of the proximity to not only the river, but the floodway line and the floodway buffer lines, and the proposed layout of the single-family houses on these subject lots. From the recent site visit, a view of the street from, a view of the properties from the street, a little into the interior of the property. On the left side, the views up and down Pennington Bend Road, and then from also at the edge of the interior of the property, shooting back across Pennington Bend to the multifamily unit there. The appellants will have 15 minutes to make the desired presentation. Of course, if you wish to save some portion of that time for rebuttal, it should come out of this originally allotted 15 minutes. Afterwards, the opponents, also represented by counsel at least in part, will have the opportunity to make their desired presentations within their 15 minutes. Mr. Hargis, if you'd introduce yourself and let us, by name and address, and let us know if there's any other documents to be distributed to the board.
Sure. Thank you, John Michael. My name is Joey Hargis. I'm the attorney, 211 Commerce Street, here representing the builder, Mr. Adam Epstein, and to my right is Ms. Carol Anderson, the property owner that's here. Ladies and gentlemen, we come before you today, as John Michael discussed, for a setback variance in this case. And the numbers that are involved there, it is a 19th-foot setback variance. 39 feet is the required setback based upon the average of the homes, 4 homes, which the zoning code requires. And we are proposing to be 20 feet. The intent of our setback request is based upon hardships. As you understand, this board must find that there are hardships involved for a case, and I'll submit to you, and as I have in my submittal to this board, but also state here publicly that this case and this property does have unique hardships to it, and that affect this property. The first foremost is the topographic conditions of this property. As Mr. Michael showed in his photographs and the topo maps on your GIS show, that this property continues to drop, basically have a flat area for construction along the front of this property and then drops toward the river. We do have a couple of exhibits I'd like to submit to you. One of those is a revised site plan, which I've got, and which will have the same, it's the same setback, but it further delineates kind of the issue, the lines which are on there. As that comes around to you, this property is also encumbered by floodway and floodway buffer. Floodway buffers are an area in which Stormwater Office regulates, and this through the Stormwater Committee, not this board, whether or not you can encroach in that floodway buffer. My client is wishing to stay out of the Zone 1 buffers completely and make only minor penetrations in the Zone 2 buffer. That requires, what that means is building outside that floodway buffer. The Stormwater Office does not want that floodway buffer Zone 1 to be disturbed. Zone 2, they do allow encroachments with it, but the idea is to bring that building closer to the street to bring it completely out of the floodway and floodplain. The overall, there is no injuring to neighboring properties. Mr. Michael, if you'll pass around, I've submitted in my brief.
Joey, would you tell me what, because in my notes, there's two questions. One, you'd said that it was a 60-foot, okay, so I'm sorry, you want to, the 60-foot setback is required, but you want 20.
The actual setback required under the zoning code is 39 feet based on the.
Well, that's what your note said, 39, but in something that we had seen, I guess, from the codes department, when they make notes on why it got sent to us or why it was denied.
The original, yes, sir. And that was based upon the examiner's application of the zoning code table, which would call for triple the table, which is the normal table is 20 feet, 3 times that. That was prior to the survey being taken.
And then what impact does the property have if it crosses over that secondary flood line? You just said you were trying to get out of that secondary flood zone?
There are 2 flood zones in which you have the floodplain, which everyone's familiar with.
Right.
What you have is a floodway.
Yeah, for clarification, John Michael, can you talk to us about the floodplain and the floodway and how that affects the code?
I'm quick to point out that is uniquely the province of the Metro Stormwater Agency. Their regulations are completely unique from the Metro Zoning Code and administered by staff at Metro Stormwater. And then appeals from their regulations go to the Stormwater Management Committee, a body that works in much the same fashion as this Board of Zoning Appeals. Although we see many developments that trigger some of these questions, these are not questions that are actually regulated by the zoning staff and thus the Board of Zoning Appeals.
My question was, and I know the answer, I just want you to say it. What's the difference between the floodplain and the floodway?
It's a test.
Okay, I'll
You're not getting me to talk about stormwater stuff, Mr. Chairman.
You're not allowed to build in the floodway at all. Correct. The floodplain, under certain circumstances, you could build in. Floodway, no.
And so on this property, you've got floodplain, floodway, and then you have another line.
What I'd like to submit to you, we're not constructing either the floodway or the floodplain with this proposal. You do have a buffer, which the stormwater ordinance sets aside, that is 75 feet in width outside beyond the floodway. That's not, as John Michael talked about, that's not for this board. But it does play a role in trying to bring that building as close to the front property line as possible to mitigate the amount of disturbance or amount of encroachment that you're coming into that.
So why 20 feet instead of 25 feet or 30 feet? I mean, why is 20 feet your number?
Certainly, if the builder, Mr. Epstein, may be able to address that.
The reason for that is to keep us out of the floodplain and out of the secondary buffer, the Zone 2 buffer. We'd like to have a house that's at least 35 feet deep.
And please identify yourself for the record.
Oh, I'm sorry. I'm Adam Epstein, 3704 Hobbs Road, Nashville, Tennessee. I'm sorry. But again, that was, the whole idea was to get a 35-foot deep house. So 20 feet plus the 35 puts us right to the back of the floodplain and also to the back of the Zone 2 or 1, Zone 1? Zone 1 buffer. So we'd only have to ask for an appeal in the Zone 2 buffer, which the stormwater people have been approving based on mitigation, usually.
And ladies and gentlemen, members of the board, I'll also submit to you that in addition to this topographic hardship that exists on this property, this hardship's not self-imposed. As Mr. Epstein talked about, the requirements which Metro has placed upon these properties forces builders not only in certain situations to come to this board to ask for variances, and I've submitted in my record, in my submittal, the variances on other properties that this board has granted most recently in January of this year. And I'll have a map to pass around to you in just a moment. But all of those hardships that are involved deal with the floodway and the topographic issues that are on there. The unique part about our lot as it relates to other properties is how much of these properties along Pennington Bend are encumbered by the floodplain/floodway areas. And they do vary greatly. As I mentioned in my submittal, there's no harm to these neighboring properties, these other properties that are involved. And you'll have the counsel for the opposing counsel represents some of the folks that were granted these same variances, both post-2010 flood and pre-2010 flood. That there's no harm to those. I know many of the neighbors brought about concerns of flooding and how we're going to rescue. All of these people will have the same thing, but I think the important part that I come to you for is to allow Ms. Anderson, Mr. Epstein, to provide landowners or new homeowners the opportunity to construct here. There are clear hardships in this site. This lot is small. It is shallow. It does have topography in it. And the unique situation, I would like to pass around to you the map, the next map that's coming before you. And there are 7 copies for each of you. This shows the amount of floodway encumbrance. And I'm going to let Mr. Epstein talk a little bit about that as those come around before you.
Okay, the idea behind that was to show that what I did, I took a random sampling of lots up and down Pennington Bend. On the sheet you see here, we basically defined how much of it is covered by floodplain, how much is covered by floodway buffer, and how much is covered by floodway. And you can see that every lot is different. Every lot is unique in the way that the floodplain, because it's a river, it meanders. And because of flow of water, it changes. So there's no one lot on the street that's the same as the other lots. So all we're trying to say is each lot is unique, and that to define it as not being unique because they all have floodplain, and they all have every lot has floodplain, every lot has floodway, every lot has floodway buffer issues. It's just to the degree of it. You know, we're building up the street. We didn't have to ask for any appeals except for a buffer appeal for a deck because ours was further away. As you go down the street, it's further up. The people in the past have all asked for these same floodway buffers, floodway and setback issues, the 7 people that have asked for it in the last 10 years. So it's sort of the same, but not the same, because everybody has a different degree of it. Okay.
I would like to point out as we talk about the prior cases, many of the folks who are here today opposed, both represented by council and not, were the beneficiaries of variances granted by this zoning board. And I'll read to you, and I've submitted into the record a copy of orders that this board said in the last one that was done by this board at 2913, Mr. Yost's appeal on February 23rd of this year. Your order states the floodway buffer line that's located to the rear, parentheses west of the property, 72 feet from the front line where the setback measured should be 48.1 feet. This would prevent reasonable structure from being constructed on this subject property. So this board's recognized that on all these lots, these 7 to 8 variances you've granted in the past 10 years, you've recognized that there are hardships that are incumbent on each and every one of these. The opposition may come up here and tell you it's not unique. I would say to you, and I'd submit to you, that each of the variances you granted, you did find a unique situation in each of them. So I think you would.
How many of those were after the flood? Was it just the last one?
No, sir. And I've submitted a copy of the orders that are in there. But looking at the, I believe all of the variances that have been granted, but for 1 or 2, there was one granted to the prior owner of Miss May's property up the street in 2007. But the Lawlers, that would be not the adjoining property owner, but the parents next door, were granted in 2011, in May of 2011. As well as the Stevensons and Miss Bills, all those were granted post-flood. And then the one 2 months ago that you granted, Mr. Yost was the applicant on it. I believe the last name was Kissinger's are the landowners of that property. Again, this board needs to find that there's a hardship. I think we've both in our submittal and our testimony here that there is a definitive hardship on this, and a variance is needed in order to construct. And that by pulling the setback line forward at 20 feet, that 20 feet is measured from the actual right-of-way. You just had a case that was all about right-of-way. I'm talking to you now about street. We're 35 feet from the pavement. So 15 feet of that right-of-way is unbuilt by Metro. There's obviously no plans for Metro to ever widen Pennington Bend. That would be absurd. But so our setbacks, although they are measured from the right-of-way, we are actually 35 feet from the pavement. So it will not be out of character with any of the homes that you have.
So you're saying you're 35 feet from the pavement, and that would put you
20 of the right from the
right.
From the
So
right-of-way.
okay, 20 from the property line, 35 from the pavement, 39 from the property line is what the codes require.
Yes, sir. In the photograph that's on your screen there, the house that you see at the bottom of the photo, that is Mr. Richard Lawler's house. That house was granted that variance. That's case number 2 listed in my submittal for you. They were granted a 30-foot street setback in that case. Again, this board found that they originally had submitted. I believe in the record there a 30-foot setback in there, but the floodway buffer and topo, this is your order, the floodway buffer and topo issues forced the residents to the front of the lot, and a copy was provided to you of that order that states that. But if give you a mind, their property is almost 20 to 25 feet deeper than our client's property. They have more dirt to work with above the top of the bank. So that leads to my discussion about our lot is narrower or shallower to work with. If we had 15 more feet, we'd line up with them, and we would not be here before you. So as part of what we're having to deal with is the lot that we're dealing with is not as deep as the other lots that are there. So we've got less room to slide that back. Yes, ma'am. I would like to reserve about 3 minutes for rebuttal, but to my right is Ms. Carol Anderson. She is the landowner of the property. I'd like to talk to you about the property.
Hi, I'm Carol Anderson. My residence address is 536 Rivercrest Cove, Nashville, 37214. The hottest zip code, I understand. 29 years ago, in 1988, I purchased this property with the understanding that it could be built on. There was an old dilapidated house on there, and in time I had it, at my expense, I had it taken down, and I had it hauled off. I also spent thousands of dollars putting in rock fill to keep the property valuable, and also to remove brush. And I've paid taxes on it for 29 years. And I used to be a backup singer for Roy Clark and a professional songwriter, which I still am. But in the past 10 years, the music industry has changed. I think you've heard about that, with a lot of free downloads and with YouTube and with streaming music. Now, I brought some checks to show you my royalties lately. I got a check for 10 cents. I got a check a few months ago for 3 cents, and the most recent check I got was a check for 1 penny. Now, this cost 49 cents to mail me a check for 1 penny. So I would love to continue to have this property. I always wanted to build a dream house on the river, but through the years and the way the music industry has gone, I can't afford that. In fact, I can't afford to maintain the property the way that it should be maintained. I've tried to keep it nice as I could afford for the neighborhood, hoping that I would live there someday. But so my hardship is that I'm not asking for a favor, but I'm asking for fairness. I hate to think that this would be devastating if this property, which I purchased and paid for and have paid taxes on, is worthless to me. Thank you.
Any questions? Do you all have anything else to add before rebuttal? Let's hear from the opposition, and you'll have 5 minutes and 18 seconds when you return.
Mr. Chairman, George Dean for Lawler, who's second to my right. I'm going to ask her just to say just a few words to the board, and then maybe I can make take a couple of minutes on a more legalistic presentation. And I don't represent everybody in the neighborhood, just Ms. Lawler. This is Ms. May, who is also a neighbor. I think there's some other neighbors who probably want to speak as well.
Hi, Travis Lawler, 2315 Pennington Bend. So I've been told by others that this board doesn't always heed the argument that a variance should be denied because the hardship's not particular to a specific property. And I know the developer was trying to make the argument that this is specific, but according to Stormwater, there are 43 properties on Pennington Bend and neighboring Miami that could potentially be developed with a variance. And all of those properties are in the same boat. They're at a narrow strip of land between the river and the road. And there might be some small variations, of course there are, but I would argue that it's a general characteristic of the area. And the developer wants to make much of the fact that other variances have been granted, but in my opinion, that only goes to prove the point that this is a general hardship, not a specific hardship. Also, most of those properties were people rebuilding their flooded homes and not new development. If you approve these variances to allow 3 large homes, expect to see many more such requests in the coming year. Staff at Stormwater are very concerned about the effects such development could have on the floodplain and future flooding. As I noted when I was here in February to oppose an identical variance request just a couple of doors down, these 3 properties are literally next door to properties where flood-destroyed homes were purchased by the city to create permanent green space. Those efforts cost taxpayers millions of dollars, but those destroyed homes were mostly small homes on large lots. And if building is allowed to proceed in the floodplain as if this were urban infill, we could end up with greater density and much less green space than before the 2010 flood. And that's why Vice Mayor David Briley took the time to come to the initial hearing on this request and implored you not to grant this variance, and why our Councilman Jeff Syracuse is here today. After observing board members' comments on this and the similar variance, it seemed to me that there's some disagreement about whether the buyouts of nearby property are relevant to the current situation. FEMA's guideline on the flood buyouts says, quote, the purchased property is maintained for open space purposes in perpetuity in order to restore and or conserve the natural floodplain functions. And if the buyout of targeted homes that were likely to, if the buyout targeted homes that were likely to be rebuilt rather than vacant properties that might never be built on, that only makes sense as the best use of a limited pool of money. In fact, there are other things that can be done to prevent new construction on vacant lots, and I would argue that the council and Stormwater, at the council's direction, have done them, putting rules in place they thought would make these lots unbuildable. The property assessor certainly thought so when the city lowered the appraised value of the lots to $1,500 in 2012. My neighbor, Victoria May, who's here today, has been in touch with the assessor's office and confirmed that the reduction was because these properties were deemed unbuildable. But apparently with enough variances, you can get around those rules. But I would urge you to follow the intentions of the council and the recommendations of Stormwater and deny this variance. Again, I emphasize the fact that other variances have been granted does not mean you have to continue granting them ad infinitum. I think it underscores the general nature of the hardships. The properties in question today are already taxed as though they were undevelopable. If the owners of this and similar properties need further relief, they should apply to the council for a general remedy that will take into account the entire area rather than seeking specific exceptions for each individual lot. And I believe Councilman Syracuse will mention more about that today. Thanks very much.
Good afternoon. I'm Victoria May. I live at 2409 Pennington Bend Road. I believe that with Mr. Dean's arguments that the appellant has actually proved that his property is not unique. all of those variants that were granted actually shows that all the other properties in the neighborhood are the same. His is no different. You've got to have a variance to build. And I urge you if you remember Mr. Louis Raisha, he was here a few months ago, and that case was taken to the court, and the court came back and said that BZA shall not grant a variance without an affirmative finding of fact on each of those standards. So uniqueness is just one of them that you have to find affirmatively. Let's see. I don't understand, and I know this is a sort of an informal hearing, but I don't understand and can't find any evidence as to why the requested side setback that was initially in this appeal was withdrawn. I don't know who did it, when it was done, how, where, why. And I spoke yesterday about trying to find that out and appealing that determination by whoever made it to this board, and was informed this would be a separate item A appeal. And I'm going to appeal to this board as laymen that you would make a motion to include a full review of that issue, since it was originally in this appeal, as to why the said side setback variance request was withdrawn and whether it was for proper reasons under the code. And if that means you defer this to put that together, so be it. But I think it's ridiculous when we've got the same property, the same parties, the same issues, the same board, the same record, the absence of a rule as to how to address that, the fact that you would go to Robert's Rules of Order, and this, if not a substantive issue in this case, then I plead that it be a procedural issue, and let this be heard for me. Or I can pay my $100 and I can do an item A appeal, and we're back here again, same property, same people, same issues, et cetera, et cetera. And I thank you.
So where do you live? You said you live on Pennington Bend, and how long have you lived there? Did you?
Since 2014.
This year. Okay. And then a new house, an old house?
It was built before the flood. It was built in '07 on the exact footprint of a home that burned. And the original home was at a certain distance from the street. And Candace and Catherine Rust, who built the home, rebuilt that home, had to go through the formality of getting the front of that house approved, even though they could build to that. They needed approval because
So when you say approval, do you mean a variance from this board?
That's what I mean. Thank you. That's what I mean.
So I guess why was it fair for your house to get a variance? I'm sure based on the same argument that this appellant's making, and this appellant not get that variance.
Well, the variance that was given to the house that I live in was pre-2010, and as I said, it was '07.
And you didn't ask for the variance, right? You bought it that way.
It came that way. I didn't ask for it. You're right.
Right.
It
But no,
came that way.
the home is on your property because it had a variance granted by this board.
I don't know that that's the whole story, but that certainly seems to be what the
Well, or let's just say
documents
this,
say.
one of the necessary requirements for your home to be there was to have gone through this board.
According to that document.
Right.
And I don't have another document, and that's why I'm bringing up
So
casually this other issue.
Well, and again, and I don't know what the rest of the board, I mean, we're only addressing the front setback issue, and that's all we're charged to address. And there may be other issues that are there, but I mean, that's really all we have on our docket, so.
Well, that's why I'm informally requesting you to consider that other issue, because it is inextricably intertwined.
But I guess the question is for, all the neighbors. I mean, you said they're all the houses are the same, and there are a lot of variances. It's a complicated issue, and I know we'll hear from Mr. Dean in a second. But
yeah, good.
But why is it? I guess I'll just hold that. I did ask that, why is it fair?
And the other thing I want to say is I believe Mr. Harper asked the lawyers in this case to give a little statement about public welfare or good at the first hearing when the earlier hearing. And I just want to say to you, Mr. Harper, that the legal definition, as I understand it, is that a public good or public welfare is something that's available to everyone, such as a park, police, fire. It's paid for by the taxpayers, and everyone has equal access, and the access is consistent to all. So if these houses go in, people come and stay there. When it floods again, who's going to rescue them? Who's going to rescue me? How do they decide? So as to the public welfare, that's my answer to that. Thank you.
Let me jump in before too much time goes. My argument really is strictly a legal one, and the board's probably heard me say this before. As the board knows, a variance is really an opportunity to give a property owner who has some exceptional physical feature or some problem with his property some relief. The difficulty is in cases like this one, where you have an entire section of a neighborhood affected by the same physical feature, i.e. the topographic condition that Mr. Hargis was talking about, that is not an appropriate subject for a variance. Now, I know the board's granted them in this area of the city before, and I understand that, and in a kind of an unusual way that kind of goes to show what I'm talking about. The folks who wrote the legislation, the Tennessee variance provision, were looking at saying in an area where you had a single piece of property, maybe a couple, that had some exceptional hardship brought about by a condition on the property, they need some particular kind of relief, and a Board of Zoning Appeals is the way to go. If you have an entire segment of properties that are suffering from a similar kind of a problem, then that's a legislative decision, not a zoning board decision. And Mr. Hargis has shown the board's granted, I guess, 8. We're looking at 3 more here, that's 11. I don't think there's any doubt but that this entire area of the city had a problem during the flood, that all the properties are subject to this problem. The right solution is a legislative solution, not an administrative solution. In a manner of speaking.
But Mr. Dean, we still have the power to give variances for cases like this, right? Last meeting, I had to mention Marbury versus Madison. I'll mention it again.
Reaching back again.
The reason that this case is in front of us is because we have the authority to rule on it, correct?
Well, I don't know that
legislative or not.
There's a little argument there because, virtually anybody can file the appeal. Whether the board actually has jurisdiction to consider it is an interesting question.
We don't have jurisdiction over variances anymore?
Certainly you do, but okay. Is there appropriate grounds under the circumstances presented here? That's the issue.
But I think you said the legislature should be the appropriate place, but we still have the authority to grant this or not to grant it.
No doubt about that. But let me take an example. Suppose somebody asked for a use variance. Now, 40 years ago, when I started practicing, this board granted use variances. That is, gasoline station in residential districts. At the time, I staffed the board. This is late 70s, early 80s. I'm showing my age. And my position then, as it is now, was, hey, you really can't do that. Over the years, the board has kind of gotten away from that. To my knowledge, I don't think this board probably hasn't granted a use variance for 20 or 25 years. That's going away. I'd suggest this one certainly is not in the category of a use variance, but where you have a large group of properties that are subject to a similar kind of a condition, that is not an appropriate subject for a variance.
How about, as a rule of thumb, how many properties would it take to constitute a large group of properties?
Really, I'm thinking, really, it should be just one or two. I mean, if you're going to grant a variance, you're looking at one or two parcels of property in the same general area for the same reason. If there's a different reason that's advanced, and I looked for, there's no case law on this particular topic in Tennessee. When I run into that problem, one of the things I frequently do, and it's not very well known, but our legislation here in Tennessee is virtually identical to the legislation in New Jersey. The folks who wrote, a guy named Alfred Bettman, wrote the Tennessee zoning enabling legislation and our variance provision. About 10 years after he wrote ours, he's from Ohio at the time. He was hired in New Jersey to write theirs. So theirs looks very similar there to ours. And a few years ago, in one of their courts, they looked at a floodplain construction restriction and said could not stand without a showing of peculiar or exceptional conditions which distinguish that property from other properties within the same floodplain. Mr. Hargis tried to do that by suggesting that the property, I guess it was to the south, he said on the picture there, was larger, but the map that he passed around as, I'll call it Exhibit 1, looked to me like the joint property line was 190, then the next property line up on the applicant's property was like 195, then it went to 200, and then 206. So it actually appeared to me as though the properties going up on that picture were expanding in size, not getting smaller. So that it doesn't seem to me that there's any distinction. Again, let me make one other observation. The councilman's here. If there's a solution to this problem, it should be legislative. Particular property owners shouldn't get a variance when everybody is entitled to the same kind of relief. That's the main point. Thank you.
When you say everybody, you mean everybody on a street or everybody on one side of a street?
No, everybody who's affected by this floodplain, it would be my point.
I mean, and I ask you the number, and only because I'm thinking of previous cases where, we've had a street that might be straight, then it goes diagonal, and so everybody's got a square or rectangular lot except for the 10 houses that are on the diagonal, and there are cases where we said, hey, that's unique. So that's clearly unique to the certainly others. But if that was a whole street, then everybody's on a diagonal,
and it would seem
nobody
like
gets a variance.
And it seemed like it would be a legislative response would be appropriate under those circumstances.
Also, Stormwater has identified 43 vacant properties that are potentially could be built with a variance. And also, for instance, my house is on officially 3 lots, which is the exact same size, 150 feet of frontage, as they're requesting to build 3 houses on. So say they build their houses, I sell my house, the developer comes in, then you've got 3 more lots. Right now it's 1 lot, but then it could be 3. And another thing I just wanted to mention, we're in a little bit of a catch-22 where we're in what used to be very rural and is still kind of a bit of a rural area with mostly small houses and large lots. And we have, I think Councilman Sirkis can speak a little more to this, but he had looked into a little bit of possibly putting in a conservation easement, which could limit the size of the houses, what could be built there. But I think planning says that's inappropriate because these lots are actually supposed to be unbuildable. So they don't want to say you can build, only the size house there because according to, if you follow the letter of the law, you can't build anything there. So, what do we do with that? Most of the houses that got these variances are small houses on large lots. That's not what they're proposing. They're proposing, as I said, it's 3 50-foot lots. They want 3, which is the same as what I have with 1 house, and each of those individual 3 houses are much larger than my single house.
And I would add the same thing. My house sits on 3 parcels that are contiguous. In fact, there's only 1 house on the road, on the whole road, that is on a single 50-foot parcel, and it actually goes outside of that 50 feet.
Are there any other folks?
Okay, any questions? Thank you. We're going to hear from the applicant and their rebuttal.
One last thing. Could we have Exhibit 3 that they presented? We hadn't seen that.
We'll look at it later.
Yes. We'll make sure Mr. Dean gets it.
Oh, I know, but I'd like it
Actually, the young lady at the end of the table, as I've explained, unfortunately won't be able to address you as a rebuttal unless there's something to add as rebuttal testimony, which I'll bring there. Would like to point out in my time, there are neighbors here, and if I could, by show of hands, those neighbors who are supportive of our request.
She wants to speak.
In support, okay, and who's in opposition here?
So I would like to, for the record, it's not everyone that does this. And I do want to clarify a couple things. Again, this is a rebuttal testimony, but one of the things I'd like to address is principally what Mr. Dean talked about, and sort of this assertion that all the lots are the same. They're all, they all need variances. My client here is built at 2207 Pennington Bed without any variances from this board, so complies with the setback. He's built on Miami Avenue. As Ms. Lawler talked about, there are 48 properties that have information. It is possible to build on lots on Pennington Bed without setback variances. These lots are far and few between, and as Mr. Dean pointed out, I'll submit to you that the survey that we showed shows this lot is 190 deep. Ladies and gentlemen of the board, that's in the river, okay? Metro's GIS shows, and you've got this in my submittal, but Metro GIS shows the actual usable space. We're talking about the space which you see on this property. Buildable, actual dirt above water, okay? And our lots are 134 and 135 feet deep to that point. The Lawlers, Miss Lawler's parents, 150. That's the 15 feet I'm talking about, Mr. Taylor. If we had 15 more feet not in the river, we'd scoot these houses back and it would not be here. As you look through all of the lots that are to the north of this property, these lots are much deeper. They're much deeper north, they're much deeper south. This particular stretch, and you see it right here in your own photograph, those blank lots where Miss Anderson's properties are clearly narrower than the other parcels to the north and south. If there was enough room to do that, we wouldn't be before this board. So the testimony that somehow you can't build on Pennington Bed without a variance is just not correct. Addressing Ms. Lawler's information, that there were rules in place to not allow these to build either by manipulation by the assessor's office of the actual value of the assessed value. Ladies and gentlemen, that's a taking, okay? When you put rules in place saying that people cannot construct, you are taking Ms. Anderson's property without paying her. Mr. White alluded to it in his prior case. It's a condemnation. We're saying to you, these lots have been here since the 20s. All of these lots. Whether you chose to build your house across all three, every lot on that property are buildable lots under the zoning ordinance, so long as you comply or ask for variances in that case. My testimony is not that you have to get a variance, but I think this board has found in each of the cases, you have found a hardship on each of these on why a variance should be granted, not only for Ms. Lawler's parents, for Miss May, the prior owner, you granted a variance in that case. As addressed to the point that Ms. May brought up, there was a council ordinance why there's no side setback. I've submitted it in my record. Council Ordinance Bill 2013-419. And it's an ordinance put forth by the prior council member, Councilman Phil Claiborne, that essentially says if you've got a lot, and I'm going to paraphrase, but this is in the record, you've got a lot that is substandard in lot size, but is a legal lot, which ours is. You look to the zoning ordinance that most conforms with setback. In this case would be RS5. So you would apply, and it says here, quote, if the applicant, and you would apply the bulk standards with the district within the same classification in which the lot area would be conforming. That's RS5.
Why is it substandard?
It's under the 15,000 square feet each lot as it's currently zoned. You're currently zoned R15.
And so, but aren't most of these lots substandard?
Yes, sir. They are. They've either combined them by deed or, but the lots that you saw on the plat I've submitted to you from the 20s, each of these lots are substandard according to today's zoning ordinance. Obviously,
but even if it's combined by deed, it still retains its three underlying.
The lots are still there, and you've heard numerous cases about that over the years. But it says, within the same classification of zoning district, R and RS, in which the lot area would be conforming, if the application of those bulk standards results in a change of minimum side setback, which occurred here, we're going from 10 to 5, then the height of the single-family structure shall be limited to 35 feet. Mr. Epstein's, houses are restricted to 35 feet in height. So the testimony that these are huge houses is just not true. They are including foundation height. This is what the ordinance says. So he's bound by those. So this ordinance allows you to use the side setbacks of the conforming lot. The conforming setback for RS5 is 5 feet, which our client does, and that's why there's no side setback. Brought that to Mr. Michael. Mr. Michael agreed, withdraw the side setback variance. So I know it's printed on your agenda, but there is no side setback variance in this case. So.
It's their time to speak. Okay. Anything else, Mr. Hargis?
As it relates to you, and I'd submit to you, ladies and gentlemen of this board, you all have granted variance here, yes, by my own testimony, by all testimony. You've granted variance here. But in each case, you did not willy-nilly do so because you granted one up the street. That is not my testimony here at all. There is a unique hardship to this property, as there were to the other 8. There are lots I've shown you in this testimony that this builder and other builders have built out here without the need for variance. So to say that there needs to be some legislative change to make all the changes, I just disagree with. I believe the councilman's going to come up and speak. And for the record, the councilman did contact me talking about that he would come here today and request a 2-month deferral to look at a potential voluntary buyout. Again, not mandatory, but voluntary. And I told him that our client would like to proceed. I would ask you all that we do proceed with this case. This proceeding will have no effect on what he's proposing to do. We're not affected whatsoever, even if the ownership changes between the parties here at the table, other than who that offer might be made. But it's not a requirement that you take it. It's not a condemnation. Metro has the authority and power to file condemnation deeds and take property should they wish to do so. I think your legal counsel said it's a very expensive process to do.
And I don't know if this is even going to go there, but if we were to grant a variance, would you be amenable to a 2-month implementation delay on the variance, just to guarantee that there would be time to work that out?
Right. They still have to go before a stormwater committee. Whatever this board's action, if you grant a variance, they still have to go before the stormwater management committee before any permits would be filed or obtained.
Being effective?
It's effectively about that time frame anyway.
So you wouldn't have an objection?
Well, I don't know. You know, of course, there's obviously a contract between the parties sitting at this table, and monies and time involved in the extension of those contracts. But to say that, you know, once today we're done, hey, permit, get tomorrow, that will not occur in this case. But we do reject long, let me say this as a response to your question. I do reject a long deferral because by the zoning ordinance's own rules, a hearing and an action by this board must occur within 2 months of filing. It doesn't spell out what happens if you don't. Some ordinances do, but ours does not. But we ask, you know, to be reasonable. If there is, we would prefer not more than maybe one meeting time if there's a deferral of this ruling. But we would ask you to go ahead and make a ruling today because it has zero effect to Mr.
Well, I wasn't saying a deferral on the decision. I was saying that the action wouldn't take effect.
I'd submit to you that we're probably 2 months out from getting a permit anyway.
Can you clarify something for me? I think we received this survey today, updated. Does this still apply where you're building in the floodway buffer, and is that why you're going to stormwater? Is this still accurate, this exhibit?
Yeah.
Yeah, there's 2 buffers, one 50-foot, one 25-foot. We'll be building in the 25-foot buffer, and that's why we have to ask for a appeal for that.
Any other questions? Okay, we will hear from Councilman Syracuse. Councilman Syracuse, welcome to the BZA. I will not ask you about royalties and the decline of mailbox money, although I know you know a lot about that.
Yes, thank you. I could talk about which performing rights organization Ms. Anderson is, but I won't
that other one.
We're good friends. Thank you. I'm Jeff Syracuse, 15th District. So the last time that this case was heard here, the applicant requested deferral. And the reason was so that we could have a neighborhood meeting to possibly discuss some sort of compromise. Well, I didn't get any request for a neighborhood meeting until August 8th, 11 days ago. And knowing that this was a council week, there is no time for me to schedule anything with neighbors anyway. So that's one reason I'm requesting this time to defer. The other reason I'm requesting a two-meeting deferral. We have a neighborhood meeting set up for September 21st. The reason why we picked that date is I don't really want to come back here 43 times for request for deferral and then to go to stormwater. If you all grant the variance, then it has to go to stormwater. So what I've been doing is, as you've heard, is trying to research a more cohesive solution to this. And what we're possibly looking at doing is there is a funding source that we have available to look at a voluntary buyout program for the properties that were not destroyed during the flood, and so the original buyout program was only for those that were destroyed, not for undeveloped properties. So we do have the authority and a funding source to be able to look at that. So I would like to have a neighborhood community meeting and bring the property owners together and with stormwater and see if they would be interested in this, and hopefully we could make it a win-win for everybody. So that's why I would like to request that.
Thank you, Councilman Syracuse. So board members, and we've had this drill before lately, we have a duly elected council person who represents the district asking for a deferral to have more time to meet with the parties, but this is a little bit different. He's trying to get new legislation and get funding together to possibly take care of maybe not this particular one, but others. So what is your thoughts on a deferral?
May I say something?
No.
We're hearing from
No,
the
excuse me.
council person.
Please sit down. Please. I'm not sure that the deferral would make any difference, especially in light of what Mr. Hargis was saying. I mean, I'm not opposed to it. I don't know that I really see a need for it, but I would defer to the other members.
Other members?
Could we defer and not have to hear the case again? Can it be some kind of continuation?
John Michael.
As a procedural question, that's exactly the right question to ask. Yes, you can in fact make a deferral for deliberation and then basically deliberate on the case, having already heard it, having already closed the public hearing. The board has the ability to reopen the public hearing even for a limited purpose if need be. But yes, you could absolutely defer to a later date and just take up the deliberation at that later date, not having to put on new proof on both sides and have all the documents and everything else.
By all means.
So board members, like I said, I'm very deferential to our council people. They got elected. They are the ones that know their district best. And if usually it's a pretty reasonable request, which I think this is, I'm leaning toward, giving this a shot, particularly if there's a larger solution to other people.
The last time that we deferred a case in this fashion, I'm a little dismayed that we're being asked to defer after we've heard the case. I mean, and all due respect to the councilman, he has the freedom to speak whenever he wants, and it really would have been nice if you'd done this before we heard this, in my opinion.
In fairness, I had asked the councilman to wait until this case was called up, and obviously we can hear from him anytime during the case, but I asked to wait until this case was called up because the item A case needed to go first, because the zoning administrator had to flee.
Still, he could have, before we started testimony, we grant elected officials to speak whenever they want, so that's all I'm saying.
Yes, but we are here. We have a request by a council person to defer the case.
I move that we defer the case 2 meetings.
Okay. Does anyone second that motion?
Okay, with the amendment that we defer deliberations for 2 meetings with the option to reopen the public hearing at our discretion.
Is that acceptable?
I accept it.
Okay, motion's been made and properly seconded. Any more discussion? Is that acceptable to the council person?
Yes, thank you.
Seeing no other discussion, all those in favor signify by saying aye. Aye, opposed. It is deferred 2 meetings.
Thank you for being
We'll have our deliberation.
Cheryl, what's the date of that?
John Michael, tell us.
2 meetings put you out to September 21st, I believe. Is that right? The board will take a brief break of a couple minutes for comfort, reconvene on the next case. And the board meeting is underway. If ladies and gentlemen of the audience would respect the board's attention. These are on adjoining parcels. They are all part of the same development project. They are different owners and different appellants, but represented by the same council. With the board's permission, we'll effectively treat this as one presentation, then encourage you to take up your vote separately on cases 161 and 170, with something more of an expeditious turn toward the board's time here. The zoning map shown here shows the property at the intersection of Charlotte and 48th. The original filing for both of these cases was to request both a parking count variance and a variance from the height restrictions on the wall on the front side of the property, shielding seating patios from Charlotte Avenue. However, more recently, the parties have made arrangements to comply with the zoning code requirements for parking. Therefore, the only variance request before you has to do with the height of the wall around the patio seating areas. Again, the subject property here going westbound out Charlotte at the intersection with 48. The aerial here shows the property formerly used as a church that actually sits on 2 parcels and will be divided for the 2 separate uses. The site plan submitted gives a sense of the layout of the interior of the subject property. Other submissions include the elevations and the site plan for the intersection there at Charlotte and 48th. My site visit, though somewhat dated now, shows the property in its somewhat current condition. The lower right-hand corner shows you down 48th Avenue as it comes off of Charlotte. Another angle of the front of the subject property emphasizing the more eastern parcel and the view directly across the street into the Richland Library area. These slides, of course, show the view up and down Charlotte Avenue at this location. Mr. Jamie Holland represents the appellant for case number 161, the appellant being Dan Cook, and the appellant for case number 170, John Stevenson. Taking up the discussion of these cases as one discussion, we'll, of course, just get the separate motions at the end of the presentations.
John
Mr.
Michael,
Holland. Yes, sir.
Is there opposition?
Is there anyone here in opposition to either case 161 or 170? We see none, Mr. Chairman.
We had previously talked about this case in preparation to this meeting as a candidate for consent.
That's correct, Mr. Chairman.
What does the board members do? I flagged this for consent, and I thought it was a good case for consent. Both of them, yes.
And that's specific to the wall height issue, now that the parking issue is gone, which is the reason you didn't put it on consent, is that right?
I would recommend for our group that we put this on consent, both of these cases.
I do have a question, though. How far away is this wall from the sidewalk?
John Michael?
I'm going to have to defer to the appellant for the particulars on that, Mr. Chairman.
So I'm going to ask one question. So how far is the wall from the sidewalk? And while you're,
I mean, I assume it's on the property line, but how far?
From the sidewalk on 4710 is 5 feet, and from the sidewalk on 4708, which is the other case, is 9 feet 3.5 inches.
Okay, so I mean, and the only reason for the question was that if this were ever to become a complete street with the grassway and then the sidewalk, there is 5 feet space between there.
Okay. Are you fine with that? Okay, so
I'm not fine.
you're not?
No.
Okay. Well, then we're here.
Can we just ask some questions?
Oh, sure, of course.
It's a 6-foot-high wall, and what's it made of? Is it transparent, or not transparent, but can you see through it, or is it solid?
Well, we wanted to.
There was an elevation in the Business Journal. Is that going to be part of is that the accurate elevation?
There's a landscape elevation, John Michael, if you could.
Okay, so it appears to me that there's still just a lot of questions, so we'll just proceed with the case. John Michael?
Wait, I just want to make sure that you don't want a deferral. Is that?
No.
I do not.
Okay, so
Consent sounds
John
great.
Michael, I know we still have a bunch of cases to go, so let's just move on this one.
Sure. The aerial here, again, shows the corner property, and Mr. Holland, forgive me, I believe these are only 3 renderings we've got in the case file, but the board, of course, has the full packet and every document that's been submitted. So I'll direct the board's attention with regard to any questions about elevation, site plans, or other documents submitted. Those will be in your packet. With that, again, Mr. Holland represents on both cases, and we'll allow him to make the desired presentation to the board.
Thank you, Mr. Chairman. Jamie Holland, 511 Rosebank. This is Dan Cook. Mr. Stevenson, who owns the other property, had to leave for an airplane, so I apologize. But the applicable provision here is 1712-040E26A, and it might go, Ms. Carpeniak, to your question. And it says, you know, we're talking about an obstruction within a setback, and the applicable distance from the street right-of-way is 10 feet. So according to the site plan, on 4710, which is the church, we're at 15 feet 5 inches, and from the what's going to be the restaurant, I believe that's 19 feet 6 inches. So well off the applicable setback distance. And as far as the height, it's going to vary between 4 and 6 feet depending on the grade, but it's an opaque fence, but it has varying heights within that 4 to 6 feet. So as, you know, if you were dining out front or having a drink, talking to a friend, sitting down, you could engage in conversation as opposed to listening to traffic on Charlotte Avenue. And, you know, there's going to be landscape buffers, but, you know, not only beyond the patio wall, but also between the sidewalk and the proposed wall. And the purpose of the wall is to engage the street and the sidewalk. John Michael, if you could, with the PowerPoint slides that I gave you. I made it easy, John Michael. I called it PowerPoint slideshow because that's it. And so this is at 48th and Charlotte, and you can see where that building is out to the sidewalk, and you see our dumpster right there in front. So actually, if you look at the shadow, that's a pretty good indicator of where the wall would be minus the landscape buffer. So it would engage opposite the street or across the street at 48th.
You mean the shadow in the grass, not the shadow in the street?
Right, the shadow in the grass that follows along with the law office right there on the corner. If you go to the next slide, please. And so on the other end of the restaurant, you know, we've got, you know, what some might say dated development with a parking lot or drive-through out in front of McDonald's. Next slide, John Michael. And then where is that, Dan?
That's, I think, the corner of 50th and Charlotte.
So further west.
So you see the street wall.
Next slide, John Michael. And this is, you know, kind of the same situation. They just finished building the sidewalk in this image, you know, different type, but building out to the sidewalk, and that's just down the street too. John Michael, should be, yeah, one more. That's just another example. One more. And that's just the applicable provision of the code that I just read to you. Next slide, John Michael. Next. And that's the landscape elevation, just show you the difference in the height of the wall itself. Next slide, John Michael. Hey, that's it. And so not only would would it be outside the applicable distance requirement, but, you know, it also engage the street and match the surrounding area. And on August 7th, we met with the Planning and Zoning Committee of the Nation's Neighborhood Association, presented to them. No opposition. On Monday, just this past Monday, we met with the Sylvan Park Neighborhood Association. Let them know what we were doing. No opposition there either, pending your questions. Mr. Chairman.
Any questions for the applicant? Do you have anything else to add? We are going to close the public hearing. Discussion.
I think it's a nice project. I think it'll add to the neighborhood. I appreciate that they're taking the historic building and saving the building and making a good use of it. Appreciate they worked with the neighbors, and there's no opposition in an active neighborhood. I think it meets, I think it's fine.
And I appreciate they have some parking in place, that they got rid of that variance request too. So is there a motion? Okay, motion's been made for approval. Not approval, a motion has been made and properly seconded.
We're going to do the two cases.
We're going to do one at a time.
So we're doing
We're doing 161.
161.
Any more discussion?
I just want to say that I've had the pleasure of being at a party at one of Mr. Cook's places. I don't know what we call it, but he certainly did a good job of making that property a very nice place that fit into the neighborhood. And I feel like he'll certainly do that again.
And I asked for the elevation, frankly, because it was really a nice job. And I know Nick Drun's here, and they just did a really nice job. And that was why when they said, "What's it made of?" I said, "Well, there's a picture in it, and it really does look cool." No, it was in the Business Journal when they announced. There was a picture in the Business Journal saying, "Hey, we're looking at doing this." It's really nice.
Okay. Any more discussion? Seeing none, all those in favor of the motion to approve case 161 signify by saying aye. Aye. Opposed? Passes unanimously. John Michael, how are we going to take the second one?
We would just solicit a motion from the board as to case number 170.
Okay. 170. Do I have a motion on that?
Same thing.
Same.
I move approval.
Okay. Is there a second?
Second.
Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor of approval for case 170 signify by saying aye. Aye. Opposed? Passes unanimously. Good luck.
The next case to come to the board is number 2017-163. This involves the subject properties at 2021 and 2023 Beach Avenue in Council District Number 17. Dwayne Cuthbertson is the appellant on behalf of the case. Mark Nevers, the owner of those properties. The original request was, I'm sorry, are we hitting pause? No. Come on forward, if you would, please, gentlemen. The request was originally for a special exception for the reduction of street setback and then also a variance from sidewalk requirements. It's my understanding from speaking with the, or from confirming with the appellant and also from speaking with the council member that the special exception request is in fact being withdrawn, and this is going to be merely proceeded on as a variance request regarding sidewalks. Is that correct?
That's correct.
Great. So the RM20 zoning district is what's in play here, Mr. Chairman. You see from the zoning map the relative proximity to South Douglas where it intersects with 8th Avenue South. The aerial gives you a sense of the subject property in something fairly close to its current condition. From my recent site visit, the two houses that are on 2021 and 2023 are shown here on this slide, and the next gives you a view up and down the street of Beach, and then the view directly across the street to the multifamily property located there. It's my understanding there is opposition to the case present. Is that correct? Is there anyone here in opposition? No is a big deal.
Well, we were in opposition to the original request of the variance setback.
Okay, we're just doing sidewalks today. Is there anyone here in opposition to the variance request for sidewalk? Okay, seeing that, we'll have 10 minutes to make the desired presentation. If you would please introduce yourself by name and address.
Absolutely. Mr. Chairman, members of the board, Dwayne Cuthbertson, 1010 Ackland Avenue. And since we've eliminated the special exception from your consideration today, and we're only taking up the variance, my presentation will be very brief. Effectively, we're asking for a variance of the current sidewalk requirements to keep the sidewalk that's in place. There's a 5-foot sidewalk out in front of this property that extends along the entirety of this block face for Beach. And accompanying that 5-foot sidewalk is an 18-inch grass strip. There is an interruption of that grass strip in front of our property to accommodate driveways. Our variance request is, again, to eliminate the code's requirement for a 5-foot sidewalk and a 4-foot grass strip. What we'd like to do, with your permission, is keep the 5-foot sidewalk in its current alignment with the sidewalk up and down the block and extend the 18-inch grass strip across the remainder of the property where that driveway currently exists. One of the intents behind the grass strip is to act as somewhat of a space for utilities and street furniture. And there is a utility pole, actually there are two utility poles in front of our property. One of them exists entirely within the grass strip. And then there's one that divides our driveway. And with field measurements, we've confirmed that if we extend our grass strip up as 18 inches, that utility pole will fall right entirely within that 18-inch grass strip. So, we feel like this particular block face, our property, is unique in that if we are required to do the sidewalks as they are asking, we would have to bump our 100 feet of sidewalk in 2.5 feet and effectively push it out of alignment with the sidewalk that exists on the entire block face of beach. And if this were a redeveloping area, if this were a greenfield area, I get it. At some point, we're all going to get to that standard. But we've got relatively new townhomes that occupy just under 200 feet of frontage to the north of us. And then immediately, or not immediately, but at the southern end of this block, there's a property that's in historic. It's contributing. Chances are it's not going to redevelop significantly at any point to where it would require the new sidewalk standard. And so we'd effectively have 350, 60 feet of sidewalk along this block face that will never likely won't get redeveloped and have that 5-foot sidewalk and 18-inch grass strips. So we'd kind of be the anomaly.
How do you access this property if you take out that curb cut?
There's an alley along the backside.
Oh, that's right. So it's a similar layout to what you had before, except you're just knocking off a couple of units to meet the setback.
The unit count,
in terms of access and road, I mean, I remember the drawing. You accessed it from the alley, and you had parking, visitor parking in the alley, and so it'll be the same type of access.
It will. There's some debate as to whether we can keep our access off of beach. And we've got to work that out with Public Works. They may want us. There's some in the neighborhood that want us to keep the access off of beach and not use the alley. So we're going to hash that out as we go along. If we keep the driveway along beach, then we'll have to improve it up to the point with the grass strip. If the driveway is eliminated, then we'd like to take that grass strip all the way up the block.
Anything else to add?
I think I'll rest at this point.
Okay, any questions, board members? I know we're going to hear from Council Representative Sledge, but we have our sidewalk expert here from planning, and I would like to bring him forward and talk to us about this case.
Good afternoon, Board. I'm Michael Briggs with the Planning Department. Also wanted to just briefly introduce, because you may see us some different faces before you over the coming months. Elwin Gonzalez is another transportation planner in our department, so you may see him, me, or Peter Bird before you over the coming months.
So we have your recommendation in our packet, so tell us about your recommendation and why did you come to this conclusion?
Sure. Really, our decision on this comes down to the fact that they're disturbing most of the site here. The standard here is a 4-foot grass strip, 5-foot sidewalk. I think you can tell from the photos, it has a varied grass strip in that area. The 5-foot sidewalk ties in on both sides. We feel that with the increase in the residential units under the existing zoning, that they'll disturb much of the site. Also, the proximity, I believe John Michael pointed out on the overall map that it's in close proximity to 8th Avenue. So there at Douglas and 8th Avenue is planned for a future rapid bus route. And so we think this is our opportunity to improve the walking conditions in this area.
Anyone have any questions for Michael? Nope. Thanks for being here. Councilman Sledge, finish us up.
Thank you, Board. So 3.5 hours ago, I think I came to you and said that we'd want to see the sidewalk, I guess, improved to agree with the disapproval. neighbors who have spoken with me who have stayed here throughout have said they are fine with the current sidewalk standard and fine with the appeal. Personally, the real issue that comes in is not before you, is all the residents I've spoken to around this property would like to keep the curb cut so that folks were entering in from Beach instead of entering through the alley, which is very narrow and needs some infrastructure work that I'm going to be working with Public Works and Stormwater on. Having said that, they said that they are fine with the current sidewalk standard. I know planning is recommending disapproval of this. So it really comes back to y'all. It seems that from the neighborhood standpoint, the importance is not so much the width of the sidewalk or the grass strip, but it is keeping the curb cut off of Beach. So.
Okay. Any questions for Councilman Sledge? Thanks for being here. Okay, we're going to close the public hearing. Discussion. So we're just talking about the sidewalks now.
Well, it seems to me that if we, I don't know what the math is here, but, if they end up keeping the curb cut as it is, they're really not talking about that much sidewalk anyway, and there doesn't really seem to be any opposition to leaving it the way it is. I'm okay with that variance. Also, the utility pole being right smack in the middle, as they are wont to do.
Okay, more discussion, motion?
It's the chicken and egg. At what point, I don't want to appear to disrespect planning and the new code, and yet we continue to see not many. We're not loaded down with sidewalk variances, but we start to see some that are, have a 2-foot strip, not a lot of neighbor opposition. They're bright white, meaning they're probably not that old. I don't think anybody's gone and pressure washed these. They seem fairly new, and there's a sense of wastefulness, and yet at the same time, members of our board have said if we don't take the opportunity now, when do we take it?
Corridor near 8th Avenue, right?
And I will say I do respect the argument about it being mostly disturbed and more multifamily. I do think that's an element that says, the more folks you have on the property, maybe the bigger advantage you have of being.
So what about paying into the fund? Do we?
Well, I think that's not our. I don't know that that's our. I think you can say.
We've now lately recommended
we
people
can
do
now.
that. Yeah.
Oh, we can say that now.
Yes, we can.
Oh, we can grant and make you pay. Oh Lord, I don't want to have to. Why did they make us? Why did they give us that responsibility?
Because we didn't have enough to do already.
I liked it better when it was just yes or no.
So I have a question maybe for Michael Briggs.
We'll open up the public
okay?
hearing again, and Mr. Briggs, come back,
Yeah.
please.
So this pole we're seeing here, if they planted the 4-foot grass strip, it would encapsulate that pole, right?
That's right.
Okay.
Yeah.
That was it. That was easy. Close the public hearing again.
So I would like them to actually build it to Metro standards to alleviate that problem for pedestrians, because it's really hard. I walk on sidewalks all the time with these poles, and they're only 4 foot wide, and you try to get by, and people are running by you, and I think it would help the public if we did not allow the variance.
How would it help the public?
Because the pole would be in the grass, and then the sidewalk would be wider as well. Believe me, I do a lot of walking in.
Yes, and I noticed the city has now put up a bunch of walking signs, walking neighborhood signs, so.
So I'll make a motion to disapprove the variance request.
Okay, motion's been made. Is there a second?
I'll second.
Okay. Any discussion? This motion's been made and properly seconded. And all those in favor of the motion signify by saying aye. Aye. Opposed? Okay. It passes 6-1 to 9. 5-1. John Michael. Where did John Michael go? Yeah, okay, so we're calling the next case, which is case number 182, King Interiors. Please come forward. And John Michael, I just called case 182, which is where I think we are now on the agenda.
It is, and as you'll recall, Mr. Chairman, this is a case that's been before the board in the past regarding the property at 1071 2nd Avenue South. The appellant is King Interiors LLC. Josh Helmer is the owner of the property. Mr. Helmer is here to represent the case. The question before the board involves street setback. The variance sought would allow the construction of stairs to the presently unstaired front door of the subject property. As you'll recall, Mr. Chairman, the site plan submitted shows the layout of the property and correctly identifies the location of the stairs. Again, just for the benefit and clarity of the record, this was a matter that was before the Board of Zoning Appeals in 2016, also with regard to a street setback. However, the property constructed right up to that varied street setback did not account for the stairs. So we're back having that conversation. The aerial here shows the proximity to several other single-family and two-family homes along the 2nd Avenue South corridor. And again, from the site visit, showing the views up and down 2nd Avenue and then directly across the street. Is there anyone here in opposition to case number 182? Seeing no one, Mr. Helmer will have 10 minutes to make the desired presentation to the board should he need that much, and the board would then be able to deliberate.
Josh Helmer, 1071 2nd Avenue South. Thanks for having me back. Like Councilman Sledge said earlier, there were a few questions raised by the neighbors, not regarding the stairs, but things that we wanted to get taken care of. So we had an as-built done. I believe it concluded that everything that we had done was correct and everyone was happy. I went around the neighborhood and spoke to some of the neighbors and showed them some renderings that I think you might have. I'm not sure. Do you have the? Okay.
They're in the packet.
They're in the packet. Of these stairs, and I got some approval. I think we had 15 or 16 signatures. I can't remember exactly what the count was. Mr. Sledge and I have talked several times about them. It doesn't seem to be an issue with the stairs. It was mostly the other questions raised. Like John Michael said, when we got the front setback, we overlooked the stairs. We did not know the rule that the stairs were not allowed to be in the front setback. I sat down and had a conversation with Mr. Herbert. He told me typically they're allowed to be 6 feet in your front setback, but maybe that wouldn't be the case since we already asked for a variance. I would have to just speak to you about that.
So the stairs you're building have the metal railings and not the brick sides now? Is that the difference?
What we want to do is build the concrete stair with a brick side, but metal railing on top of that. They will not be full brick sides.
So does it look like this that you gave us?
Correct. Yes, that's what we would like to build.
Right.
Is brick on the sides, concrete stairs, and then a metal railing.
And so that's what you're asking for today?
Correct. I'm just asking for the variance to build the front stairs.
Any other questions of the applicant? Anything else to add? Nope.
I don't think so.
We're going to hear from Councilman Sledge again. Councilman Sledge, thanks for brokering this and coming back and staying through our long meeting.
No, of course. Since our last meeting, the applicant and I have had a couple of conversations, had conversations with the neighbor as well. In fact, just texted the neighbor while we've been in this meeting. They've said, look, we're not going to fight the stairs. We've gotten the as-built that were requested. In fact, got them, I think, late last week. As the applicant mentioned, I think there's going to be some ongoing conversation that'll need to take place just as neighbors. But as for what's before you today, I feel comfortable with it going forward.
And thank you for your getting involved on this case too after our deferral. And I think everyone probably agrees that you have a better product now in your district.
Sure.
Okay.
Thank you.
Thank you. So we're going to close. Any questions for
Wait,
Councilman Sledge?
Not for the councilman. Can I ask Michael Briggs a question? He's probably not expecting it, though.
Oh, well, come forward, sit at the table.
Isn't this 2nd Avenue? Is that right?
That's correct.
And so what isn't 2nd Avenue supposed to be widened for sidewalks and bike lanes? And will these stairs in the future ever get in the way of that?
I'd have to look at the site plan to really be able, I'm sorry, I'd have to look at the site plan really to be able to determine.
So it doesn't live in your head?
No, it doesn't. And I was actually working on some other stuff while y'all were talking about this, so I probably shouldn't give my opinion on it without,
Okay,
fully
I caught you
looking
off
at
guard.
it. Yeah,
but,
I'm sorry.
But it is something to be concerned about, and could the stairs be oriented instead of straight out to the side, maybe?
And that was something that we had looked at after I had a meeting with Mr. Herbert. We have 2 egress window wells in the front so that stairs cannot go sideways into it. We're trying to make the landing as small as possible. I'm working with, I guess, codes now to find out what my landing is. I can hopefully be up to 7 feet off the sidewalk. Minimum is 5 feet off the sidewalk. So I think there would be some room for widening still. There's some houses that exist that are much closer right now. I don't know what we would do in that instance. But we would be someplace between 5 and 7 feet off the sidewalk.
Okay.
And the gate could open outward if we needed to be, if the sidewalks were widened.
Any other questions?
Just one quick note. You'll remember from a few weeks ago, the Shiloh Missionary Baptist Church, when we were doing theirs, their stairway runs right up to the sidewalk. So he would by no means be, I think, an exception when it came to the street.
Any other questions? Okay, thank you all. Close the public hearing. Discussion. So this came back to us, councilperson agrees, the applicant agrees. Is there a motion? I move that we approve case 182, giving the variance to the front setback to construct the staircase. That's the motion.
I'll second.
Okay, motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes unanimously.
The next case to come before the board is
Thank you.
2017-183. This involves the property at 5229 Earhart Road. The appellant, Andrea Smith, and the property owner, Thomas Bauer, have filed the Item A appeal with regard to a short-term rental permit. The permit application was denied based upon the property having been previously used as a short-term rental property without the legally required permit. Face of the property from the assessor's website and the aerial view of the subject property. The appellants, is there anyone here in opposition to this case? Formally seeing no one, then there will be 10 minutes to make the desired presentation to the board. Please introduce yourself by name and address. If you were present at the beginning of the meeting, you know the council member has already spoken on the matter. And Mr. Chairman, you'll recall Councilman Glover, of course, had asked the questions about property standards enforcement case that remains underway, the stop work order that was posted on June the 19th, and the fact that as recently as yesterday at 3 p.m. there was still a listing on VRBO for the subject property and its short-term rental, which is not presently permitted. Any questions of staff, we'll try to answer best we can. However, the time is for the appellants, 10 minutes to make the desired presentation. Please introduce yourself by name and address.
Hi, good evening now, I guess. My name is Andrea Smith, 5229 Earhart Road. And we have one issue with we have a few issues with the property. We're sitting right on this corner, and we have taxes and deeds in Mount Juliet, and we have utilities in Hermitage. We also can be searched under a Nashville address. So there are 2 different zip codes for the property. And we purchased this property middle of December of 2016 and took several months for renovations and things like this. And we live there full-time. It's our primary residence. However, both of us are in the aviation business, and we travel immensely for work. And so in purchasing this property, it's 5.2 acres, and the house is a 4,200 square foot log home originally built in 1776 with some additions. So it's quite an elaborate, historic of a sense home, and it's cherished quite a bit by us. But with such a large property and us being gone a lot for work, our idea of short-term rental came into play to help us compensate for the mortgage and things like this. So when we decided to try to do the short-term rental, we started looking at our taxes and deeds being in Mount Juliet. I called the city of Mount Juliet, Chad his name, last name has lost me, I think it's Swallows was his name there. And I emailed and also left messages, and I got a call back from a lady in his department, and she told me that there were no permits or licensing required for the short-term rental properties for Mount Juliet. And so we proceeded forward with doing, getting everything set up. And when we got the notice in June, mid-June, for the Metro permit stop action, we went down we got on and started researching and got the required documentations that we needed to show to go and apply for the permit, and that's when it was completely denied due to operating prior to. So we applied for the appeal at that time as well, and we've just been kind of waiting to try to get that information.
So in the meantime, according to John Michael, you're still listing even though you know you don't have a permit.
So I guess that's just misunderstanding of listing. I had canceled everything on the Airbnb site as well as blocked out everything so that the house is unavailable for rental. And I haven't gotten any requests for anything except into spring of next year, March, April, things like this. And everything that has come to me, I have said, unfortunately, we're unable to rent at this time due to permit restrictions.
So you have no people coming right now?
No, we canceled everything on our reservation list, and I've blocked out the whole year up until, the first of the year, just trying to catch up.
So why is it still listed on VRBO then?
It's everything's blocked, so it's unable to be rented, and so there's no way anyone can, because there was like an automatic rent thing that you can set up there, and we stopped that. So, and I blocked out everything, so it's unavailable for rent. It's just, I guess it's active on there, and we didn't go in and close out that site as being active.
Our law, it's not necessarily just the rental that is a violation of the law. It's the listing. If you don't have a permit, you're in violation of our laws with short-term rentals.
And I guess that's just, I have to blame that on ignorance of understanding or,
Well, help me out here. You thought this house was in Mount Juliet instead of
Our tax deed that we pay taxes to are for Mount Juliet, yes. So actually just yesterday, we got something in the mail that they've been trying to reach us. We have
Who's they?
Actually the property assessor.
Of Wilson County or Davidson County?
For Davidson County, since they sent out property assessments, because they weren't able to get mail, and mail had been returned just for our property assessment. So this corner of this, I think the county line and the city limits, everything is kind of right here at this point.
So who do you get your water from?
Utilities utilities come out of Hermitage.
Metro Water.
Yes.
So if you get your utilities from Metro Water, wouldn't you think you're in Nashville?
Who do I pay my taxes to? Mount Juliet.
My name is Thomas. I'm on 5229 John Hager. So there's two different addresses. It's very, very complicated. It has been an ongoing issue and very frustrating about this.
Even our mortgages from when we originally bought the property, we didn't get any of our mortgage paper from our first main mortgage on this house, and we continuously called. They would remail. So this is a huge issue as far as us and the property. That's still no reason for us to still have an active listing on Airbnb, but we're asking that this is why we're here, so that we can rectify and try to make sure that all the correct permits are in place and that we can use the property when we're living there to help subsidize by doing the short-term rental. We definitely, when we decided to do this, and Mount Juliet told us we didn't have any restrictions or needed permits, we went to our most adjoining neighbor. She has 3 acres next to us, the Selfs. We spoke with her, told her our intentions. She and I text and talk regularly. Also, the neighbor behind us, we have about 2 acres of forest and wood on the property. We went and spoke to the Maynards behind us, talked to them. The people who owned the property before us had short-term rental there as well. They were two ladies that lived there, and they did it as well. And so we went through this process, but it just kind of got jammed up along the way. And so we're just here trying to rectify
I'm
and
still
make sure.
stuck on this Nashville versus Mount Juliet thing. So have you voted in the last few years?
I just voted for president, but
And where did you vote?
well, in November, I lived in Rutherford County.
Oh, you live in Rutherford County.
Yes, sir. So I voted
What is
in
your mailing address?
5229, well, it's confusing. Some mail we get at 5229 John Hager Road, Hermitage. And then we also get mail in the same mailbox as 5229 Earhart Road, Mount Juliet. We also get mail as 5229 Earhart Road, Hermitage.
Well, I live close to this area. I come that John Hager Road, and I'm aware it is on the Wilson County line. But it is interesting to know where your legal address is. When you bought the property, what does the deed say?
Mount Juliet, 37076. But we have trouble getting.
Wait a minute, 37076 is a Hermitage.
Sorry,
zip code.
37122.
That's
Yeah.
Mount Juliet.
Yeah, so I have all three addresses written down here because whenever I go, I've gotten mail going to the Hermitage mail post office. We've also gotten mail to the Mount Juliet post office for things as far as our mortgage and bank trying to get things to us correctly.
Okay, so next question. When did you find out there was a law related to short-term rentals and that you weren't in compliance, and when you started to cancel all these future bookings?
When we got the notice on the door, well, we don't watch a whole lot of television, so people are telling us about the news, and so we were thinking, well, we needed to try to start paying attention to this because of the zoning differences and things, and we got the notice on the door on June 19th, I believe, or June 20th. Sorry, June 16th. And so then we came down here just within a week's time after we collected all of the
And
information.
when did you cancel all these future reservations?
Well, the stop notice, but we had bookings all the way through. So up until mid-October, we had bookings.
So there are none of those people, you canceled every single one of
I
them?
went on and canceled on the Airbnb site.
But what about the other site?
Pardon?
The other site, did you cancel those?
Oh,
Do you have any
on
book-
VRBO. Yes, I've canceled all because it's,
So you
it's
have
not
no
allowed.
future short-term rental bookings anywhere?
No, everything's been canceled out.
Okay, but it's still listed on this other site?
But it's all blocked off. We're not taking any reservations. And in reply, I have asked, I said, we are unable to rent at this time due to permit issues. We have a meeting coming up, mid-August. Please check back after. I may be able to. And I also have warned them that, in looking for a short-term rental, they must have that posted on their site or they could run into the same issues.
Sure.
So.
Okay. Anything else to add?
No, we're just trying to rectify and make sure that we're doing everything like we should so that we can, stay on par. I might have a question briefly about the address for zoning for if it's in Davidson County or right on the Wilson County line. I assume that this would come back to the Board for Zoning Appeals as well, because this is a huge problem that we're
It
having.
sounds like your house is in Davidson County, and I will ask John Michael the Marbury versus Madison question again. Is this properly in front of us as being Davidson County property?
Yes.
So this is in Davidson County, this house. Okay. Questions for the applicant? Do you have anything else to add?
I did want to say one thing about the Councilman Grubber, I believe is his name. All of the other councilmen that have been here today, they seem to have spoken with both sides of the argument on the appeals. I don't even know who this man is, and if he's had complaints about our property, which he stated, or any of our neighbors have complaints, I don't know any of our neighbors other than the two that are adjoining to us. Like I said, the Selfs, she and I have a very good relationship, and she is the closest one to us. And I'm a little disappointed that Councilman Grover got complaints and had issues about this, yet he could look up our information and contact us, put a letter in our mail, come knock on the door, and we can discuss these things, and he could have potentially had a side on both as opposed to coming in and just kind of blasting. I felt really like I was needed to get defensive.
It's
So
really not his job to do that. It's kind of codes enforcement to come and send notices and enforce the law or talk about violations. But yes, I mean, the duly elected officials, and as you can tell, there's lots of things going on in people's districts. So they don't necessarily reach out to every single person that comes in front of this board.
I understand, but I just feel like it would have been nice if there were some complaints or there were some issues that he addressed enough for him to take his time and come down here today, that he possibly could have reached out to us. That's all I wanted to address on his side of that. So that's all I have to say.
Yes.
Yeah, it is an absolutely stunning property, and like Andrea said, it originates back to 1776, which to me, that's a big deal. The wooden floors we have in the first floor, actually from the Vanderbilt Gymnasium. So there's lots of beauty and lots of, I guess, history and interesting things with this property. We are here because we want to do everything right. We want to, have people come to our place, be able to come to our place and enjoy it with us, and enjoy the Nashville area. And that's all I wanted to say about this.
Okay, thanks. Anything else?
How big is your property?
It's just a little over 5.2 acres, and the house is about 4,200 square feet.
Anything else? Okay, we're going to close the public hearing discussion.
It does appear to be a unique case. I don't think we've heard this one yet. I think it feels like they've done almost everything that we would normally ask of people to do. I think it's the first time we've had one that's not taken it down but is blocked. So I guess what I'm saying
But to remind everybody, the violation is the posting.
is the
as well.
posting, right? So I feel like I've never had any, it's always been like they've posted or they haven't posted. This seems like this is like an effort to not post it, but not quite. So I guess what I would lean toward, is maybe, that we would find in favor of the zoning administrator, as we do on these often, and make the appellant eligible for the permit in 30 days from today's date, if I were making a motion.
Are you making a motion?
So moved.
I second.
Okay, motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye.
Aye.
Opposed? Passes. So what we have ruled today, in 30 days, you will be eligible to apply. Not that you have a permit, you will be eligible to go through the process of Davidson County. So,
And don't advertise until then.
yes, don't.
Okay, I'll take it off this evening.
Because if
and
you
then-
advertise and it still remains up, these folks can call you back in front of us again.
Okay, I appreciate it. Thank you very much. Yes, we were counting on that. We just haven't edited anything and stuff like that. So we know the rules, and so we will take it down and it will be back.
Mr. Chairman, we'll move on to the next case, which is case number 2017-205, involving the subject property at 312 Clark Hill Crossing. Karen Farabin is the appellant and owner of the property at this address. It is, again, a short-term rental case, technically an item A appeal, challenging the zoning administrator's denial of the short-term rental permit based upon having operated at the subject property before obtaining the required permit. Is Ms. Farabin present? Please come forward, ma'am. Is there anyone here in opposition to case number 205? Seeing there is one. So, Ms. Farabin, you will have 15 minutes to make the desired presentation to the Board of Zoning Appeals. In the event that you want to save some portion of that time for rebuttal, that'll come out of this originally allocated 15 minutes. And after the opponents speak, you'll have a chance to come back if you wish. Toward that end, please introduce yourself by name and address and make the desired presentation.
Good afternoon. My name is Karen Fairbairn. I live at 312 Clark Hill Crossing. See, I want to say that I started I've been looking for ancillary forms of income, as I'm sure a lot of people are at this particular junction. So I decided to post on Airbnb just to see what kind of response I would get. I did this back in February, didn't get a lot of response, and so I closed it down. Again, I opened it up again early July, I believe, maybe even earlier, and got a lot of responses. It was crazy, and I started accepting them, and I started pulling everything together to get my permit. Unfortunately, I thought that I would be able to get my permit just by walking in and bringing all of my documentation. The day before I planned to bring everything in and get my permit, and I had a stop order put on my door. I had posted and I had accepted listings, which I didn't realize was wrong. I thought that it would be the acceptance of cash and actually transacting the business. When I went to apply and found out that I needed the permit and it wasn't going to happen right away, I shut everything down immediately. I canceled all of my reservations and closed the site down. I've since had a hearing last week where that was dismissed. So the actual operation of the short-term rental, they decided that it was not, that I had not operated and there were not any penalties.
Did you go to environmental court? Is that what you're saying?
Yeah, I don't quite, yes, that is what it is. Yeah, honestly, I didn't really understand the difference between the two things. I'm very new at all of this.
Can I get I just want to get a clarification on the environmental court issue.
I actually don't handle short-term rental cases in environmental court anymore, so I handle the overall docket, but short-term rentals are assigned to another attorney, so I don't remember this particular case. If it was dismissed, it might have been dismissed. I don't know why it was dismissed. Did you work something out with the attorney ahead of time? No. The judge heard the case.
The judge heard the case last week.
Turn your mic.
The judge did hear the case last week at my recommendation, and so they decided to
So the judge heard your
dismiss.
case and determined that you had not been operating without a permit?
I want to say yes. They decided that it was just that the whole thing was dismissed, there would be no penalty, and I would simply pay the court fees.
And again, I don't recall this because I wasn't handling this case. If it was heard by the court and if the judge dismissed it, the judge would have found that she was not operating without a permit.
What about, and I know you probably can't answer, well.
You can ask it. If I can answer it, I will. If I can't, I won't.
It's just getting late. And the council lady brought up a lot of issues, problems that I think would
Yes.
go to environmental court, or
I'd really like to address what
Those would be separate environmental, I mean, that would be, to the extent those would come to environmental court, they would come to environmental court separate from they would be separate codes violations. It would be different cases.
So you want to address what the councilperson
Yes,
said?
please.
So who are these people? And
I think, first of all, I'd like to have time to talk to her about it because there's some confusion. I'm at 312 Clark Hill Crossing. The issues are happening at 309 Clark Hill Crossing. Yes, the gentleman that owns that property has gotten sick and has moved out of state. His daughter is maintaining the home, and she has taken in different renters, not short-term, but long-term. She's made some bad decisions, as far as I can tell. The gunshots and all of the bad things happening in the neighborhood, I personally haven't witnessed. I have seen more cars and things like that. But this is not my property, so it's a whole different issue.
so here's the big issue too. This house is, or you are part of an HOA, right?
That's correct.
And your HOA, according to Alice Bowen, does not allow this.
And that is something that I was not, I did read through my HOA agreement, but I didn't read it with that understanding.
Well, this is what it says, use of premises. Each lot shown on the plat shall be used only, emphasis added, for private, single-family residential purposes and not otherwise.
Okay. I do know.
I want to ask a question about that. Haven't we before decided and determined that CCRs we don't have any control over
We
CCRs?
have in the past, but
cannot.
John Michael, the new laws say what?
Ms. Sanford, you hit it right on the head. We do not regulate or referee the terms of HOA agreements or covenants or anything along those lines. However, the ordinance that governs short-term rental properties, which is codified now at 17.16.250 subsection E, actually speaks to the fact that Metro confirms in the application process whether or not there are, in fact, HOA guidelines in place that would forbid that type of operation. And that was a change in law that I think took effect either in early 2017 or late 2016. I'm sorry, I don't remember which ordinance it was. But as a result, when somebody comes in to apply, they're going to have to sign an affidavit saying, I swear and attest that there is either, number one, not an HOA in effect, or number two, there is one, but none of their terms and guidelines prevent me from having this operation. So ultimately, if I think I could say it accurately on behalf of staff, that's not really the thing to stop you one way or the other from any motion today before the board, but it would be in effect once they come in to apply.
In our ongoing education here on the Metro Nashville network of other people seeing this, I want people to know that if they go to apply, that they have to have either no HOA or HOAs that don't prohibit short-term rentals. So
I think we have clarity on the environmental court issue.
Oh, we do? Okay.
Yes, apparently the case was dismissed because the judge found that she had not operated without a permit. She had simply advertised without a permit. And advertising and operating have two different penalties.
Okay.
And I'm sorry, but when I did go to apply, they did ask if I had that it was my understanding that you did have to have something up on a site to show them when you went to apply for the short-term rental permit.
No.
Is that inaccurate?
No, that's very inaccurate.
Because I believe I heard the gentleman, not that I was speaking with, but next to him saying, you need to, he was going through someone else's paperwork and said,
There are things that you're supposed to bring with you, like floor plans,
Right.
and, inspections and insurance, proof of ownership. But no,
Yes.
you're not supposed to post and advertise before you are duly given a permit.
And Mr. Chairman, on behalf of staff, this is a clarification we have to go through pretty frequently, and the courts have even had to have this explained to them from time to time. Not disparaging to say it that way, it's just not entirely clear for everyone. For those who choose to use the insurance products offered by the listing agencies, such as Airbnb, VRBO, whomever else, it's imperative that the reviewing zoning examiner be able to see that that insurance is in fact connected to the property listed through that website. So some people will come in with, I don't know, State Farm, Farm Bureau, whatever insurance, and here are my documents. Those who use the insurance offered by Airbnb or whichever other website, we have to see that online. Thus, it's going to be connected to the listing. That is not advertising the website, making it available for rental or whatever else, but we do have to be able to see the insurance at least. So that may have been the confusion there.
Thank you for that clarification. Anything else to add?
The only other thing that I would like to say is that I would love to have the opportunity to speak with my HOA and the other members of the HOA and
Yeah, as John Michael said, that's not
explain,
us. So,
right. But I think, again, I believe that there's a lot of confusion over my home, which has had myself living in it, and my neighbors where there have been a lot of issues. And I just want to make sure there's a lot of clarification there, not only with my councilwoman, but also with our homeowners association.
Okay. Any other questions of the applicant?
Have you spoken to your council lady?
I have not. Today was the first time that I saw her.
I would suggest that you talk to her.
Yes, sir, thank you. I absolutely will. And yeah, I would like to live in a safe neighborhood as well.
Okay. Any other questions? We're going to close the public hearing. Discussion. So to, I guess, remind everyone, we are here. This is a item A appeal of the zoning administrator's denial of a short-term rental permit.
I'd like to propose we defer this until we hear back from the council lady, or at least I do.
Okay.
Who's here today.
More discussion?
I can't support it, not presently.
I'd be in favor of a deferral.
Okay.
Yeah, I think.
Make a motion?
Yeah.
Do we have a motion?
And Mr. Chairman, if there is in fact a motion for deferral, may I, in the interest of our already completely bloated September 21 docket, suggest that that be heard on either September 7 or October 5?
Okay.
Okay, September 7th, yep. Okay, someone make a motion?
I'll move we deferred it on September 7th.
Okay, motion's been made. Is there a second? Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. We will hear it on September 7th. So in the interim, no postings, no rentings, and talk to your councilperson. John Michael.
Mr. Chairman, the next case for the board's consideration is 2017-206.
Are you ruling is her case is deferred?
Yes.
Okay.
Yes.
The next case to be heard is case number 206 involving the property at 14B Fern Avenue in Council District Number 5. Jason Costello is the appellant and owner of that property. It's a short-term rental case. The item A appeal involves the denial of the short-term rental permit based upon prior operation at the subject property without a permit. Face of the subject property shown here, the area of the neighborhood shown here. Is there anyone here in opposition to case number 206? Seeing none, Mr. Costello will have 10 minutes to make the desired presentation. Please introduce yourself by name and address the board.
Hi, thanks. Jason Costello. I actually live at the property now in question. I moved to Nashville about a year ago and started looking, so I was not familiar with short-term rentals at all. Did some properties back in Louisville, Kentucky, where I'm from. We started looking at it looked like a good investment, so we started looking at some properties, found one, bought it in this developing area. So we started down the process of getting the permit in good faith. Our intent was never to skirt the rules. In the beginning of May, we went through that process. May 25th, I went into to get a permit. I had everything except two things. I needed to get, I had one of the 5 corresponding properties approval, and I needed incorporation letters from our LLC. So at that point, it was very helpful. David Frobot, I'm going to butcher his name, was very helpful, told me how do I do this. I couldn't really knock on doors because 2 of the properties are vacant, 2 are commercial. I had one approval. So with that, he told me how to do the mailing. So I immediately went to do the mailing to try to get either acceptance or proof that you tried to do the mailing. So I have that receipt showing that day I went to the post office and mailed them out. Apparently I did it wrong. I was told at the time you could take the tracking number, go on the site, just see that the tracking number tied to the address you were trying to send it to, and apparently that was wrong, so that was the end of May. So went out of town, came back. I fully expected to have the permit within a week or so once I got the property notifications. So we put the site up beginning of June. You know, that was clearly a mistake. We were just trying to get out in front of the busy season. And again, this was all kind of new to us, first foray into short-term rentals. So at that point, went in to get went on the site to see if the notifications were approved. They weren't. Went in, said, well, how do I tie these to the addresses? They said, you can't, you have to do it like this. So I was frustrated, so I did a second mailing, which also shows in the packet that went out like June 13th. So we had the site up, we were still finalizing the house. So at that point, we had a couple inquiries. There were a couple people I think that wanted to book out in August. We thought, fine, we'll book it because we'll have the permit here shortly. And then from there, the 13th I got the notifications shortly thereafter. And then I traveled for work. I was from the 13th to 20th when I had the notifications and the information I needed. I was out of the country. I came back 3-4 weeks later, right after July 4th weekend. Went in July 11th to finalize everything with the information and, knew I had violated the code and was told that I was not in compliance and so on and so forth. So the other piece that is pertinent, and this is kind of the elephant in the room probably, is that we did have a rental, and that was mid-June, June 14th or 15th. And so there was no intent to rent. As you can see, I don't know how much information you have from the site, but there was nothing rented all the way through August. So we didn't take any accepted requests. The 14th, 15th, I had friends coming in from California. There were a couple of them. They said they knew we were doing this Airbnb. I said, you have a free place to stay? They said, oh, we'd be happy to write your review just to get the ball rolling. I said, great. If you look at our site, we dropped the site to like $100 per night from like $500 to $800, just so they could book it and write a review saying it's a good house, a good area. So didn't charge them anything. I gave them their money back, but I fully expected to have the permit at that point or shortly thereafter, and we were just trying to get our name out there. And so my position is that our intention was never to skirt the rules, and so I would, I would ask that if you want to give me a penalty, give me a fine, you shorten the term for not having to wait a year, so we don't have to wait a year with this investment property to start, trying to cover any costs that we had up front.
Questions?
So this is a non-owner occupied home?
So that was the intent, because at the time I was also renting another property, but my lease has since run out, so I'm actually living there. But the request and the application was for a non-owner occupied. So I may or may not live there going forward.
So you don't have any postings up right now?
No, sir.
And you canceled all of them? You had that one person stay and that's it? And
Yes.
And you refunded their money?
Yes. I mean, the only intent we just wanted a review because we knew that reviews were critical and it's so competitive. So it was a friend of mine, and I didn't even think about the idea, but they said, hey, it's a great property, we've seen it, we'd be happy to write something for you. And I didn't even know how that worked, and apparently you had to go on the site to book it.
Did they really stay overnight then?
They did. They stayed the weekend.
Your friend, okay.
Yeah.
Any other questions? Okay, anything else to add?
Nope.
Okay, we're going to close the public hearing discussion. So getting back to the posting is a violation of the Nashville Airbnb law. If you do not have a permit and you post, you're in violation and you could be charged, or you could be punished with a year of not being able to get a permit just for posting. That being said, he had his friend, stay in there over the weekend, refunded his money, wrote a review, and so that's kind of where we are.
I'm sorry to interject. The lawyer in me feels like I need to make one point of clarification. It is a violation of the law to advertise without a permit. That is certainly something that y'all can take into consideration. The 1 year applies to if you operate without a permit. So if you only advertise, I don't think the 1 year attaches only to advertising.
Are you sure?
I'm sure.
Okay, because when we started doing these cases, I thought.
Yeah, the law has changed a good bit over the time. The law currently reads, upon a finding by the Board of Zoning Appeals that a short-term rental property has operated without a permit, there shall be a waiting period of up to 1 year. So again, to be clear, advertising without a permit is a violation, and it is certainly something y'all can consider. I just wanted to since the law is in flux and has changed so much, I wanted to make sure we were all clear.
Thank you. That's a very important clarification.
Well, and that actually gives a little more weight to some of the approaches that we've taken also, especially to folks that advertise without actually renting, or in this case, and I've been in the situation where I was the friend staying with a buddy in Massachusetts wanting to write, and I said, hey, this is great, I'll write a review, and you actually had to rent the place to write a review. I couldn't write a review because I didn't rent the place.
Right.
And so I have experienced trying to do what the applicant said, so I think that gives some credibility.
Any motions?
So I'll move that we find that the zoning administrator did not err in his decision, and I don't guess we need to make any findings further than that, do we, counsel?
You ruled that he did not err, or that he did err?
He did not err, and therefore the applicant is
when is he eligible to apply for a permit?
Eligible to apply for a permit today.
Okay, motion's been made. Is there a second?
I'll second.
Okay, motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously.
Thank you.
So what we have ruled today is you're eligible to apply for a permit. We don't give out permits here, but you can apply for a permit and follow all the rules, and then after you get your permit in hand, then you could advertise.
We will be model citizens. Thank you very much.
Thank you.
Mr. Chairman, the next cases presented to the board are two cases that will be heard in conjunction, given the fact that they're the same request on adjoining properties for the same project. This is cases 209 and 210 involving the properties at 520 South 11th Street and 518 South 11th Street, both in Council District Number 6. The aerial zoning map shown here shows the proximity of 11th just below Shelby. The site plan submitted gives a nice sense of the proposed property. This is the one for 520. This is the one for 518. You'll notice a striking similarity of the lots and some differentiation among the two projects. The request before you is for a variance from sidewalk requirements, hence the presence of planning staff member Michael Briggs at this profoundly late hour. The site visit shows the photos up and down 11th Street here in the view directly across the street. These photos show the two lots at issue 518 and 520. So you can have a sense of the property as it exists presently. The appellant is John Gill, the owner of the properties, New Century Builders. Is there anyone here in opposition to this case? Seeing none, the appellants will have 10 minutes to make the desired presentation to the board. Gentlemen, if you would introduce yourself by name and address the board.
Good afternoon. Bruce Gill, 714 South 12th Street, and I'm one of the owners of record of the 520 South 11th Street address.
Well, if I can learn to work the button here, I'm John Gill of 12474 Old Hickory Boulevard, Antioch, Tennessee. I am the builder, and I'm tired, so I'm sure you all are too, so we're going to kind of keep this short. I'll let Bruce do most of the talking, but we'll have 3 key points to this that we'll bring to your attention.
What we're asking for is a variance from the present or current sidewalk ordinance so that we may proceed under the prior ordinance under a hardship request. At present, what's perhaps evident from the photographs is what is currently existing is we regard a vintage brick retaining wall that abuts the current sidewalk. And then in order to accommodate the new sidewalk requirements, it would require the removal of that. We presently have in place about a 5.5-foot sidewalk. There is approximately 1 foot, 2-foot grass section between the road and the sidewalk. So this would require the removal of the retaining wall that runs along contiguously between the two properties in order to make accommodations for the widening of the sidewalk. In so doing, it would also impact, we have 2 large mature trees that are positioned just behind the retaining wall. And in order to remove that and to reconstruct another retaining wall with adequate drainage and things of that nature, it is evident that it would be fatal to these 2 large trees, which we would like to be able to retain as well. And then finally, what may not be evident from the photographs is that the retaining wall along these 2 properties abuts a retaining wall of the property at 516 South 11th Street. So by virtue of moving the sidewalk in, what you would do is you would be placing a retaining wall behind the adjacent neighbor's retaining wall, which would ostensibly make the sidewalk less traversable than it presently is. And the sidewalk seems to be in good working condition. We would just like to be able to keep it where it is in a linear position just as it is, and so that aesthetically along that section of the street, it would also be in conformity with the neighbors. South 11th Street, there are a number of properties on that particular side of the street that have already been redeveloped within recent years, so we don't expect that there will be the eventuality that all of these sidewalks would ultimately align under the new requirements. And so again, for purposes of the neighborhood and accessibility and aesthetically, we would like to be able to maintain it in its current condition.
The staff, I believe, had recommended approval and that they, with the condition that they pay into the in lieu account.
We'll ask Michael about that afterwards.
Are you guys willing to pay?
I'm tired talking, man.
So do you understand what our sidewalk fund is? Press the button. Can you press the button? And so are you willing to pay into the sidewalk fund in lieu of having to improve this sidewalk?
I think that would be best for the community and the properties and all that. We'd be willing to do that.
Okay. For both properties?
For both
And I
properties.
guess well, maybe it's a question for staff, because I was thinking the similar thing. I appreciate that, but also think that there's a legitimate topographical hardship. And so I was thinking, I'd much rather see this applicant put a curb, put a curb in, that doesn't seem to exist, or replace that to actually improve the sidewalk that's there, than to pay into a fund that goes somewhere else. So it's enhancing it, but that may be the same thing. Anyway, we can talk to the planning staff.
Well, let's hear from Metro Sidewalk Czar. Michael, come back and tell us what your thoughts are.
Your discussion has summarized it well. I think when we look at the site, we think this is a hardship, and that they should be relieved of actually constructing the sidewalk. I think how we view it is, in these instances, we would like to get the in lieu fee simply because we have such a deficit throughout the county on sidewalks, and so we view it from that perspective, that at this location, since it's obvious they can't construct it, that a fee would be an acceptable solution.
Okay. Any questions for Michael? Thanks for being here, and thanks for staying at this late hour.
Sure. Thank you, guys.
Okay.
Now you can go home, right?
Soon. So let's have the applicant come back forward. So any other questions for the applicant? None? Okay. Well, you get to.
They were agreeable to that.
They're good. Okay. So we're going to close the public hearing. Discussion. Is there a motion?
I'll make the motion to approve the sidewalk variance, and the applicant will pay into the in lieu fund.
Okay, motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor signify by saying aye. Aye. Oppose? Passes unanimously. Good luck, and thanks.
And Mr. Chairman, do we understand that to be applicable to both case 209 and
Yes,
210?
that we combine the cases on the
No
front end.
problem. Separate orders will be in the mail.
209 and 210. Yes, thank you.
Mr. Chairman, the final case to be presented to the board today is case 2017-211 involving the property at 2165 Baker Road. Harvey Latimer is the appellant and owner of the property shown here on the zoning map in Council District Number 10. This is an STRP case. The appellant operated prior to obtaining the legally required permit. There we go. Mr. Latimer, I believe, is present. If you'll come forward and address the board. Is there anyone here in opposition to case number 211? Seeing none, Mr. Chairman.
Casper says no.
Yes. That will be 10 minutes for the appellant to make the desired presentation. Please introduce yourself by name and address, and you'll have 10 minutes if you need them.
Press the button. Yes.
My name is Harvey Latimer. I live at 2165 Baker Road. And I am trying to get a short-term rental passage. Let me just tell the board, I was ignorant of the fact of the permits that was needed in order to rent my home. I found out that I was in violation of the law, and I immediately had my wife take down the listing and went to Metro to apply for the proper permits. I want to be in compliance with the law.
So what happened when you went down to get the permits?
When I went down to get the permits, I filled out all the paperwork. I took the drawings and with the fire escape, fire notices, and then they told me that I need to go before the board.
Because? Why did they turn you down?
Oh, no.
Or not accept your application?
Until after I went before you guys.
Why do you have to be in front of us?
because I listed illegally.
And rented too?
Yes, we rented to one particular person, yes.
Yeah, and we see the review on,
You only rented it to one?
We, we have done it a total of 2 times that we have actually charged. We have done it for, I am a teacher at Meharry Medical College.
did you
and so we have given them-
find this teacher from an online listing though?
We believe that they found us from our online
Okay.
listing, yes.
So, yeah, because I mean, there were 4 reviews one from May 16, September 16, April 17, and May 17. But the April 17 said it was canceled, is what the review said.
Yes.
And then I guess okay, so the May 16, was that the Meharry event, or was that person, or what? I mean, one of the reviews says that they had a professional social event there. So I wasn't sure.
Yes, and so, yes, all the professional events was from Meharry.
Okay.
So you have removed any postings or listings of any
All
site?
posting and listing has been removed.
And you don't have any future bookings that are coming?
We have no future bookings or listings.
Did you have to cancel any?
I think we had to cancel one, yes.
Okay. Any other questions for the applicant? Hmm? Anything else to add?
I want to be in compliant. I would like to have another shot at it. And outside of that, no, nothing else.
Okay. Thank you. We're going to close the public hearing. Discussion. So here's a very typical case where someone listed a few times, rented a few times, found out that they needed a permit, canceled everything, pulled down all the listings, and is asking us for a second chance. as they
I
say.
will move that we find that the zoning administrator did not err in his decision, and we find that the applicant is, good Lord, I just ran out of words, eligible, thank you, for permit tomorrow.
Okay. Motion's been made. Is there a second?
Second.
Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes unanimously. So you are now eligible to apply. So you don't have to wait. So you could go through all the procedures and things like that. So good luck. And of course, this is the end of our BZA meeting. I hope that everyone enjoys Eclipse Monday, and see you outside.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.